Yes.
May please, Your Lordship. Lordship, I pay for listing unlisted matter for criminal petition, Your Lordship. We are filing today, Your Lordship. We are paying for listing unlisted today, Your Lordship. A criminal petition, Your Lordship, challenging a proceeding pending before the court of judicial magistrate, Your Lordship. I pay for unlisted of this matter.
Next week.
Today, Your Lordship, for unlisted.
On
Your Lordship.
Friday.
Lordship, date is fixed on 7, Your Lordship.
Huh?
Next date is fixed on 7, Your Lordship.
Friday.
Can it be
It's a
tomorrow?
new
Lordship?
filing.
New filing, Your Lordship. Or tomorrow,
Tomorrow or day after.
tomorrow, Lordship. Tomorrow. Okay.
Yeah, please, Your Lordship.
Yes.
Item 33, Your Lordship, I am withdrawing, Your Lordship.
You
I
are
have
withdrawing.
instruction. Yes, Lordship.
I'm not forcing you, huh?
I'm not saying, Your Lordship.
Mr. AKC, learned concepts of the petitioner. Submits that he may be allowed to, on instruction,
Lordship.
he may be allowed to withdraw the writ petition. Praise the Lord. Next matter, accordingly, writ petition is then dismissed and withdrawn.
May please.
Lordship, I beg to mention item number 6.
6.
Yes, matter may be listed after a week.
Matter
may be listed after a week.
I think after a week,
Yes, Lordship.
on the prayer of Mr.
Jita.
Gita, learned counsel, appearing for Mr. K. Lolan, learned counsel to the petitioner. List this matter after a week.
Deeply obliged.
Lordship, I'd like to mention item number 7. I own on behalf of the petitioner side. Leading counsel M. Bagra is out of station due to his father medical emergency, and AI psychiatrist is also on medical ground. And matter may be listed after 2 weeks.
Mr.
Here are
Learned counsel appearing on behalf of Mr. M. Bagra, learned counsel for the petitioner. Submits that his senior Mr. M. Bagra is indisposed due to medical problem. Mr. Devo prays for listing the matter after
2 weeks.
2 weeks. Praise the Lord, list this matter after 2 weeks.
Yeah, please, Lordship.
Yes.
I beg to mention item number 9 on
9.
behalf. Yes, madam. On behalf of Mr. O. Modi, dating counsel for the petitioner, Lordship.
On the prayer of Mr. O. Modi, learned counsel for the petitioner, list this matter after
3 weeks, Lordship.
4 weeks.
4 weeks. Deeply obliged.
My Lordship, I beg to mention item number 8 with consent from the petitioner. The learned conducting counsel are Raksa is out of station. So this matter may be kindly list after 1 week.
But will not extend the interim prayer. Interim order. Will not extending it.
I'm just for the respondent.
He's for respondent.
Okay, I thought he's appearing on your behalf.
No, my
Okay.
lord. He's for
On the
respondent.
prayer of learned counsel for the parties. Mr. Peter for respondent, for petitioner, and Mr. T. Rowling, learned counsel for the respondent. T. Rowling. List this matter after 4 weeks. Interim order was earlier shall continue.
Yes,
Since you are not praying.
no.
Pending matter. This matter will be fixed on 6th of August.
Why?
Because there is urgency in the matter.
What is the matter?
This regarding title dispute in the form of this 2nd April.
Title
Application is
dispute.
filed, yes. Title dispute. There is urgency.
I'm very averse to second April.
Yes.
List after 2 weeks. 2 weeks. Just after 2 weeks, then let's.
May I please, Your Lordship? Your Lordship, I beg to mention item number 18.
Yes.
Your Lordship, that I for the petitioner, Your Lordship, we are ready to file the reply in the affidavit. So your lordship, deponent is out of,
Declare of MS, your name please,
C earring.
see Learned Counsel for this petitioner,
Yes, your lordship.
list this matter after
You, 2 weeks.
2 weeks.
Your
So
lordship,
as to enable her to file affidavit in reply.
your lordship, actually CRP 17 and 16 is an anomalous matter. So your
List
lordship,
this matter along with CRP 18 of 2020.
no, 16/24.
16 of 2020.
Moreover, your lordship, interim may be continued.
Interim order was earlier. Before the uses.
Maju belum.
Sir, why you are not wearing gown? Why you are not wearing gown? So what emergency do you have here? Don't repeat it again. It's for you only.
My lord, I'd like to
Yes.
appear for the petitioner, my lord.
Yes.
This is a fresh petition, election petition.
It's all
Yes,
within time.
yes, within
Any
that.
defect?
Yes, no defects. We have filed the Form 25 also, the affidavits also.
Hard mister. We'll see. Will issue notice.
Yes, very well.
Hard mister.
Rituraj Viswas.
Raj Biswas, Learned Counsel to the petition. Next paragraph. This is an application under section 80 or
80, 80A,
80A and
80 and 80A.
80A and 80 and 80A. But you have said 81.
My lord, first para, page 4. Top of the page.
But in the post title you said 80 and 81. 80 and 80A of the same part of the representation of peoples in 1951.
So,
This petition, this election petition has been filed under section 80 and 80A of the representation of People's Act 1951. Following in question the election of the respondent, Mr. namely Sri Tai Nikio,
only one respondent.
as member of Legislative Assembly from 19 Nyapin within bracket ST Assembly constituency. On the ground of
corrupt practice
corrupt practice,
and undue influence and materially affecting the results of the election. So this is
which
101B
has materially
affected the result of the
affected
election.
the result of the election. The election petitioner has also prayed for. What is the other prayer?
To declare,
Declaration.
kindly have page number 60.
Declaration. For a declaration.
The election is void.
Declaration. That the election is void. And further to declare the petitioner to have been duly elected from 19 elected as member of Legislative Assembly from number 19 Nyapin within bracket ST Assembly constituency. Issue notice to the respondent, returnable by 3 weeks.
By 3 weeks.
3 weeks.
Registered.
The
My lord, as per the rules, my lord, the notice has to be issued as through registered. That is the election conduct rules.
petitioners to take steps for service of notice. by registered post, registered post
Register.
with AD
Yes.
within 2 days from today. List. On which date? Last one. Yesterday when we do. Last two. 1 month. When did we fix the last one? Well, I have fixed it.
Very good. There are other petitions.
19. 19 or thereafter. Huh? Yesterday is when we,
The other election petition.
19, 18, I'll make it 19.
Nineteenth of the August. Very good. Grateful.
21. Last one. Then in that case, next 22. 22.
22. Very good.
2208. Very good.
Very good.
Mayor,
Yes.
Your Lordship, the petitioner are aggrieved by the order dated 3/7/2024, passed by the learned Chief Judicial Magistrate Pasigat.
What's wrong?
Whereby, Your Lordship, the rejoinder replica filed by the plaintiff, respondent hearing, has been allowed and made as a part of the pleading, gross violation of the statutory provision of Order 8, Rule 9.
And Mr. Aibam and the counsel for the petitioner. Petitioners. Petitioners. Next, this revision petition is filed assailing the order dated 03/07/2024
Yes, sir.
passed by the learned Chief Judicial Magistrate. No, learned
Civil Judge,
Civil
Senior
Judge
Division.
within brackets, Senior Division. Pasigat. Whereby the replication filed by the respondents have been has been accepted on the ground that the acceptance of such replication is in violation of Order 8,
Order 8, Rule 9.
Rule 9 of CPC. Issue notice returnable by 4 weeks. The petitioners to take steps for service of notice upon respondents by registered post within 2 days.
Your Lordship, I have an interim prayer. It may be.
Well, consider the entry point. No prejudice will cause. When is the next date fixed for?
23rd, Your Lordship, 23rd August. Your Lordship.
What's there? What is this stage? On 23rd, what is this? What for it is fixed? What for it is fixed? On
Oh,
23rd?
Documentation.
Okay, you keep on. We'll hear them and pass them.
Till then, your next returnable date, it may be.
What prejudice will cause to you?
Your Lordship, they had totally changed the nature of the
Does it
case.
have any bearing on the filing of
Your Lordship, by,
documents?
your Lordship, by filing replication, they have totally changed the nature of the case. Even the territorial jurisdiction has been challenged in our reply. Oh, yeah.
Considering that the appeal order dated so and so, privacy appears to be in violation of the provision of Rule 9 of Order 8.
Order 8, Rule 9.
The appeal order
3/7/2020.
shall remain, shall not be, shall remain state. till return. It is made clear that since the impugn order is, the interim order is passed, we are hearing the respondents. The respondents may file appropriate application for modification. if so advised. Right?
Yes.
This
File-
is the 4 weeks. Yeah.
Also, this is regarding the illegal eviction of the petitioner, Malad. The petitioner has the land possession certificate, trading license issued for resort, Malad. She has constructed the tourist resort. Suddenly the ADC comes and evicts the entire structure. Therefore, Malad, it's totally illegal on the part of respondent. At least show cause notice ought to have been issued, Lord. Lordship may see the annexure one is the land possession
Forget about-
certificate.
Come to your prayer.
Yes, Lordship, I agree, Malad. Lordship, that prayer I accept, Malad. Though this
You
honorable.
filed a appropriate petition.
No, but
for
that,
damage and
Mal-
whatever compensation.
Malad, several cases, Mal, I accept.
No, I could understand if you challenge the eviction.
Malad,
Because
yes,
then you have been already evicted.
that's why, Malad.
Now, if you want the compensation,
Malad, I understand your Lordship wanted to say that
Sir.
for tortious liability, Malad, I have civil
so
remedy.
anything in such a matter when the compensation can be,
Malad,
for compensation, any writ can be filed.
yeah, no, not, this is the per se, not compensation, Malad. What we are saying is, praying is for exemplary, Malad, this is the, for a Malad order to,
Sorry, sir.
if Lordship sees in case of Malad, the Ram Leela Maidan's case, Lordship. If your Lordship, when the Ramdev was allowed to Malad, have the demonstration there, but he was evicted night, Malad, in the night without any order, Malad. That also was amendable to the jurisdiction, Malad.
Under what? 226?
Yes, Malad.
Where is the order?
Malad, I'll just,
Any compensation, they claim for
Malad,
compensation?
in case I have just lay hand only on regarding that one.
Any compensation?
Yes, Malad.
Your prayer is for compensation.
Malad, this exemplary compensation directing the state to pay, Malad. Your Lordship may not
Sir,
direct
you-
this amount, Malad.
Sir,
At least,
you read your prayer.
no, Lordship,
Please read it.
yes, Lordship.
I think you have not vetted it.
Yes, Lordship.
Yes.
Malad, why we are saying this compensation,
No, no,
Malad?
you have not vetted this draft petition before filing. I think you are appearing just today. Have you gone through?
This is the prayers, but this honorable court may not, but read jurisdiction, Malad, is always this honorable court mold the prayer, Malad, that's always there, Lordship.
We don't know whether you were illegally evicted or not.
No, that's it, illegally
You
evicted.
file a proper petition. Even if according to your, but by going by your nature of the prayer, you cannot dismiss. Withdraw and file proper. Get it drafted by junior and properly vetted in file. We'll consider,
Oblige, Lordship. Yes,
right?
yes.
First go through them and decide
Yes,
and ask them to draft and properly settle it and then file.
yes.
We'll consider.
Oblige, Lordship. Withdraw the bill and file the petition.
Am I wrong?
No.
You have not gone through, you have not settled the matter.
I've gone.
Mr. Peter, counsel for the petitioner. So Mr. Peter Bolan, counsel for the press board. Withdrawal of this writ petition. Prayer is allowed. With a liberty to file a press.
Yes.
Prayer is allowed. According to this petition, is still dismissed on the withdrawal.
I got
Yes,
Lordship.
right,
I'm
right.
obliged.
As prayed for.
Obliged.
Yes, with a liberty to file a press if so advised. Sir, what is this?
May I please, your lordship? Lordship, this is only
Your
interfering
substantive post is
TGT, ma'am.
CRT, TGT.
TGT, man. Now, my
It's
lord,
your additional post.
additional post, my lord, the way the action has been initiated is only because of the initiation on the
okay.
part of the
It's
respondent.
it's a few, I mean, it's a aberrations. Should
Well,
not happen.
My lord, just my lordship may peruse the, my lord, the office noting. Very,
First, you have to establish whether you have a right to continue in those posts.
my lord,
What is that post?
that is, my lord, the cluster, block cluster resource
These are
coordinator.
These are all temporary arrangement.
However, my lord, there is a guideline.
What is the guideline?
Guideline is, my lord, for appointment of, I have annexed a copy of the guideline also, my lord.
Yes.
Of course, it is, my lord, details guideline is not annexed. It is the minutes of the meetings and which has been adopted in the, my lord, meeting, annual general meeting held by, held on. Page number, my lord, it starts from page number 30.
Hmm.
Page number, my lord, relevant page is page number 32 and, my lord, the para point number 12, my lord.
Yes. 32.
32 page number, para 12, my lord. The EC has approved for the appointment of the BRC and the CRC and the district coordinators for the different interventions from the teachers with sound academic background. Only 10 years teaching experience with BA, BED and PhD would be the DPD and the DPOs would be appointing authority at the district level. On approval from the chairman, the EC and the regular the teachers working for SSA is BRC and CRC and the district coordinator shall be taken on deputations to SSA and their salary to be able. I'll skip this part. What I wanted to point out is, my lord, minimum qualification is 10 years, my lord, having the sound experience, my lord, background, academic background. 10 years, my lord. But the persons who is replacing me is only having, my lord, 4 months.
What is EC? EC what?
My lord, EC is executive committee, my lord.
Executive committee.
Yes, my lord.
Yes.
So therefore, my lord, at least the, my lord, and there is, of course, my lord, I have not annexed the entire things. My lord, there is a education policy for which, my lord, this CRC is the, my lord, the authority to, my lord, supervise the teachers.
So according to you, on the note of the MLA,
My lord. Yes, ma'am.
you have been chanted out
Exactly,
without
ma'am.
there being any order.
No, nothing, madam. No adverse record against
Where
me.
is the order?
My lord,
It-
impugn order is at, my lord, page number 36, madam, annexure 6. There is nothing on record, my lord, or the may read, my lord. Mr. So and so, my lord, the respondent number 5. TGT presently posted at government, the upper primary school Doimuk under Doimuk block is hereby temporarily engaged as cluster resource center coordinator as Doimuk apart from his normal duty. The engagement of the CRC is purely on temporary basis and the engaged teacher shall be reverted to his original designations if his performance is not satisfactory without serving any notice. But the important point is, performance, regarding the performance. But in my performance, there is no adverse record. Just simply, saying that only basing on the notes initiated by the local MLA.
So this is appointment of the one Mr. Nabam Bittu.
Pilot.
How it is connected with your appointment?
Yes, madam. It is in page number 24, madam.
24.
Yes, madam. Directly, madam, this has been, madam, pointed out, and there is nothing, madam, and no adverse any record, madam. There is no any complaint, madam. Page number 24, madam. This is the DO letter initiated by the local MLA, madam. I would like to recommend below names for the appointment as block resource coordinator and the clusters, the resource coordinator, ISSA, under 14 Doimuk Assembly constituency. Therefore, you are requested to consider the same in public interest and issue order accordingly, madam. Names are specifically given, madam. Serial number 1, Techi John, TGT, madam. I'm not related. Serial number 2, Nabam Bittu, TGT, directly, malad, ACRC Doimu malad, where I'm serving malad. And because of that, malad, because basing on this initiation, malad, the initiation and the no,
So, there can be two CRCs.
no malad, no malad. There is no resultant vacancy, malad. Malad, may kindly again come to page
Where's your
number
appointment?
26, malad. Page number 26, just for a moment, malad, may I read, malad? The same things, malad, has been, malad, reflected. This is not, malad, basing on the DO initiated by the local MLA. Further, it is mentions that the Honorable MLA 14 Doimuk ST Assembly Constituency has recommended another separate DO letter number so and so for appointment of below mentioned the teachers at A's, BRC and the CRC. A DO letter may please be seen at so and so, malad, again quoted, malad. Next paragraph, malad, it is very important, malad. It is to mention that there is no any resultant vacancy against the CRC Doimu, malad, where I am serving, malad. And Balizan, this is second item, madam. As the present incumbents are working sincerely, madam, and dedicatedly as per their assigned work oblique duty, and the CRC Doimuk is presently looking after the charges of the BRC Doimuk too. But as per DO letter number of the Honorable MLA 14 Doimuk has desired to engage serial number 2 and 5 by replacing the present incumbent Sri Nangbia Jikam, CRC Doimuk, and Sri TC Teli, CRC Balizan. Thereafter, malad, nothing has been changed. Malad, even malad, my sincerity, dedication has been reflected in this note, malad. And my appointment order, malad, as CRC is at page number, malad. 16, malad. Annexure 2, malad.
16.
16, malad, 1-6. First appointment, malad. This has been again modified, malad. In the interest of public service, malad, Sri so and so PRT primary school is hereby temporarily engaged as cluster resource coordinator and posted at cluster resource center Gumto under Doimuk blocks with immediate effect. Thereafter, malad, another order came by modifying the, it is Doimuk, malad, 17, page number 17.
Is there a difference between CRC and CRCC?
Malad, it is same almost. This cluster resource center coordinator, and sometimes it CRC only, malad, is because cluster, if coordinator word is used separately, malad.
Yes, sir.
Hello. As Malad has already seen, the original post is TGT, Malad. This is a temporary arrangement, Malad. Only,
But it's this the way.
Malad, that is what I'm also told. This has been done, of course, as per noting, Malad.
Yes.
And malad, importantly, the local MLA is nowhere malad connected to the department, malad. Of course, he is the representative of the constituency.
But the MLA is connected to every
Malad,
department.
where it's been taken
Not
into
only one
consideration, malad.
department. He cannot be connected.
Yes,
He's all in all.
But malad, the office noting everything, malad, there is no adverse record against me, malad. Otherwise, malad, rather their department is very much satisfied with the services, malad, rendered by me, malad, duties and responsibilities, malad, assigned to me, malad.
Heard Mr. M. Kato, Land Council for the petitioner. The challenge made in this petition is to the order dated page 36.
Malad. Malad, my relieving order, malad, as well, malad. First page number.
Where order dated 23/07/2024, passed by the Deputy Commissioner DPD ISSE, page 36, ISSE, Samagra 6, UP Papumpare district, whereby the respondent number, who is the respondent number?
Respondent number 5, madam.
respondent number 5 has been appointed, engaged, has been temporarily engaged as Cluster Resource Center Coordinator within bracket CRCC, Doimo. In place of the petitioner on the ground that the impugn order has been passed at the behest of the Honorable MLA of 14 Doimuk Assembly Constituency. In violation of the applicable guidelines for such appointment. Then, what is the other? The petitioner has also challenged the.
My relief order,
What is
madam.
your release order?
Page number 22, madam.
22.
Yes, madam. By which order I am relieved, madam?
Has also challenged the order dated 23/07/2024. Relieving him from the post of CRCC Doimuk. Issue notice returned by 3 weeks. Mr. Tita, learned standing counsel for education department.
Yes, ma'am.
Appears appears an accepted notice on behalf of respondent number 1, 2, and 4. 1, 2, and 4. And MS P. Sangita, London State Council for respondent number 3. No, in that case, you said London Standing Council for Education Department and MS P. Sangita, London State Council for respondent number 1, 2, 3, and 4. Have accepted.
Your Lordship, I'm only for 3.
Appears an accepted notice on behalf of. Respondent number 1, 2, 3, and 4. No formal notice needed. However, except officer in society. Petitioners to take steps for service of notice upon respondent number 5 and 6 by registered post with date within 2 days. Within 2 days. Next one. So you have been already released.
Madam,
You have been already relieved.
madam, the relief order is the same date, madam. Therefore, madam, my interim period may be considered, madam. Till the returnable date.
On the hard on interim prayer. Next prayer. On consideration of the materials placed. Material annexed to the writ petition. It appears that the appointment of the respondent number 6, respondent number 5. Is purely at the behest of the, is purely on the basis of the note of the Honorable MLA Respondent number 6 hearing. It appears that the authority who is to the competent authority who has to apply the mind for such appointment has not applied their mind, rather acted, prima facie acted on at the behest of the honorable MLA. Respondent number 6 hearing. Normally, such appointment is a temporary engagement without having effect to the substantive post, to the substantive post of teachers of the teachers, no indefeasible right to continue is discernible. However, in the facts of the present case, since the competent authority has not appears to have not applied their mind, rather acted only on the basis of the note of the honorable MLA. While issuing the impugn order dated 23/07/2024, by which the respondent has been appointed, engaged as CRCC Diamond. I deem it appropriate to state the impugn order so and so. Accordingly, the impugn order dated 23/07/2024 and order dated order dated impugn order and the release order dated 23/07/2024 still remains suspended till the returnable date.
Well,
List up to 3 weeks.
deeply. Same,
Same CRCs.
same,
Balijan.
names are only different,
Names are different,
same order, my lord.
same order, same day,
Everything same, my lord.
same day.
Same day.
But place is, it's a CRCC.
CRCC.
Same
Both
CRCC.
One is Balijan, this one is Doimu, another is
Place
Balijan,
Balijan.
and the private
Name
respondent is
and the
also.
respondents, 5 is different. Petitioner's name and the respondent are
Well,
different.
Exactly.
Place
everything
is
same.
Balijan, right? Same impure.
Same. Deeply.
This report, Lordship, in respect of private, all the respondents from 1 to 4 completed, Lordship.
You have taken Dusty for respondent number 3.
3, yes.
What
Lord.
about 2 and,
It was served through the register first with AD card.
yes,
And-
what about 1 and 2?
1 and 2, 1, 2 and 4 on last occasion, their
Already
service.
served?
Yes, served. They have been served through their concern commandant for respondent number 2 and concern OCPS of for the respondent number 4.
No, last order 2905, it says respondent number service of notice upon respondent number 4 is complete. However, service upon respondent 1 and 2 is still not complete. You have taken Dusty on respondent number 3.
3.
What is to be done?
Lordship, I think 1 and 2 also completed.
Served in response to receipt from the. And the same is placed. Okay. Office note dated 17/7/2024 reflects that ID card in respect of respondent number 4 and 5 are received back. Therefore, the notice, service of notice upon respondent 2 and 3 are complete. Next para. The landed consensus petitioner has filed an affidavit. You have filed already. Filed an affidavit in respect of justice service to upon respondent number 3. The same is taken on record. The service of respondent number 3 is also deemed completed. No, therefore the service of notice upon respondent 3 is also completed. List for admission after 3 weeks.
In the meantime, Lordship, there is an interim.
Interim order was earlier shall continue. Yes.
Deeply also.
Your Lordship, we have recently received the reply in affidavit from the private respondent.
Mr. So-and-so, learned counsel for the petitioner, respondent is granted 3 weeks time to file affidavit in reply to the.
No,
affidavit.
we have received it.
Affidavit.
They have filed the affidavit.
You want to file reply?
No, I am the petitioner here.
That's what I'm saying. You want to file a reply to the affidavit?
Yes, hearing may be fixed, your next.
No, learned counsel so-and-so for the petitioner submits that he has received the contrary affidavit filed by the private respondent number 4 to 17.
Yes, your Lordship.
4 to 17.
The comment has also filed.
It is also submitted by MSG at the London Additional Senior Government Advisor that she has also filed the affidavit in opposition on behalf of the state. List for admission.
Yes. Admission.
Pleadings completed. Pleadings completed. List for admission hearing.
Yes.
After
Obliged.
4 weeks. Yes,
May I please, Your Lordship? Your Lordship, this IA has been filed. The IA has been filed for,
where it is.
for withdraw, Your Lordship, it's here. Your Lordship. For withdrawal of the.
Any objection?
One time, has made observation on 17/5/2024.
Yes.
If the council wants to file affidavit of in office, to know that it is filed by authority,
Yes.
to come with the under which they filed. That has made.
There was,
And their affidavit which is that IA which is filed has been made no mention of any procedure which under which provision of law the affidavit filed by the respondent can be withdrawn. So that is one aspect. And other than I would like to find
Your Lordship, there is an order passed on 18 July, Your Lordship, in this month.
Just tell us,
There is,
under what provision you can withdraw the affidavit filed by you?
there
mention in
is no
IA.
such provision in the.
So when there is no provision, how can you be allowed to withdraw? What is the ground of withdrawal?
Ground of withdrawal is, Your Lordship, there is an inadvertent mistake, Your Lordship, made by the staff, Your Lordship.
Yes, will allow.
One of the I mean allowed to file official.
If it is,
If, Your Lordship, this affidavit is
One of
not
the-
corrected. Your
it is
Lordship,
not the correct, if they have filed the affidavit in opposition, which is not been corrected. Incorrect affidavit in opposition. What's the bar?
Well, the matter is, since last 15 occasion, they have been just lingering for filing just affidavit for more 2.5 hours. And after since April, they are again lingering for withdrawal of their affidavit.
Had Mr. MSP Sangeeta, learned counsel for the petition applicant. Learned district counsel for the applicant. Now, yeah, we're allowing,
My lord,
we'll allow.
no, I have
we're
objection.
allowing it.
I have objection, my lord.
Your objection, I'll record it. I'll record it.
Others, I may be allowed to file my objection petition in this regard.
You said they are lingering. Again, you yourself is trying.
No, in this regard, I may be allowed to file objection.
Your Lordship, there is
And the
a
matter may
state,
fix on Monday.
Yes.
That is order
Yeah,
in his favor, Your Lordship, that is right.
Mr. No, yeah, I had MS Learning Council, State Council for the applicant. Mr. I had this application is filed by the state for withdrawal of the affidavit in opposition. While on the ground of,
Your Lordship, there's an inadvertent,
on the ground
Mistake.
that the same has been filed without correcting,
yes, Your Lordship.
properly correcting the,
To file a corrected,
there occurred a mistake and uncorrected in the affidavit in opposition, for which the same may be allowed to withdraw and file a fresh affidavit in opposition. Next para. Mr. Modi, oh sorry, Mr. Nebo, learned counsel for the Nebo, learned counsel for the opposite party petitioner, public petitioner, has vehemently opposed the application on the ground that there is no provision for withdrawal of the affidavit once it is filed and registered. When it is filed and registered. However, on the pointed query, Mr. Nebo could not point out why the such prayer should not be allowed for withdrawal of such affidavit. And for that, Mr. And he submits that he may be allowed to file an objection.
Yes, my lord.
Whereas for the learned, Mr. Nebo, the learned counsel for the opposite party petition and is granted a week's time to file objection. List on
Monday, my lord.
7/07/08/22. If you don't
Obliged,
come up with a provision that it cannot be allowed, will impose a cost on you.
My lord,
Ready?
if I'm allowed to file
Ready?
the objection, that is sufficient.
Not only objection, you'll have to show that why this cannot be withdrawn.
Yes, my lord. I'll make my own ground. Most obliged. my lord.
All right.
I'm a very good respondent.
All appears for the petitioner on call, Mr. G. Riba, learned counsel for the respondent, learned counsel for respondent number? Sole respondent.
Three, Three
Respondent number 3 is present, list after 4 weeks.
Your,
Affidavit,
yes, my lord.
yes,
I put a respondent number 4 and 5. Yours.
4 and 5. So
We need to file affidavit in opposition.
that submission you made on seventh of May, June, July. After, before 2 months made the same submission. Are you not interested?
I have, Your Lordship, I have no idea. I have only instructed to tell.
Mr.
Yellow and Lordship.
Yellow Lands Council for the petition. Government you have filed?
Yes,
The
Your Lordship. For
respondent
respondent number two,
to
we have
file.
filed our counter affidavit.
MS. P. Pango Learned Council, Legislative Council has submitted the, she has filed the affidavit. She has already filed the affidavit on behalf of the state.
My lord, I will not profile it.
Mr. D. Kamdu, Land Standing Council for the Land Management Department submits that. He is not required to file any affidavit. You rely on the affidavit filed by the state. Mr. So-and-so,
After 1 week,
press for and is granted 2 weeks time to file affidavit. Affidavit as a last chance.
highly
So
honored.
Wait.
there is an interim order.
Interim order first and let's continue.
Madam,
Yes, Your Lordship.
Yes.
Madam. Highly honored.
Yes.
Yeah, please, Lordship.
Affidavit,
Lordship, pleadings are
who
complete.
is 1 and 2?
1 and 2.
On behalf of respondent 1 and 2. 1 and 2 and 5 to 17.
2 I'm representing, Your Lordship.
Okay. There's no, have you filed the affidavit?
Yes, Your Lordship.
Okay.
And they have already filed a reply also, rejoinder.
You want to file reply?
No, Your Lordship.
No, this petitioner,
They have already filed.
reply has also been
Rejoinder, they have already filed.
filed. Pleadings completed. I heard the learned counsel, heard Mr.
Bye.
So-and-so learned counsel for the petitioner. And also Mr. You're appearing.
I'm for
And Ratan, learned additional advocate general for respondent number 1 and 4. Yes. 1 and 4.
I'm for 2, Your Lordship.
MS 2 and 3. And Anju. Learned counsel for us. Pleadings completed. List for admission hearing after 2 weeks.
Obliged.
Yes, tell us. 16.
My lord, we are yet to receive affidavits from respondents.
Respondents, we have filed. Private respondent.
May I, Lordship?
Yes.
Lordship, I'm on behalf of the leading counsel, Aringo. We need more time to file
File
affidavit.
affidavit.
No.
My lord, on the last occasion, also it was directed that
You're for?
I'm for the petitioner.
No, you're for.
Respondent 7 to 17,
They were directed to file without
5 to 17.
7 to 17.
7 to 7. What about 1 and 2?
We have filed on behalf of 2 and 3.
Okay.
So 3 and 4.
Mr. So-and-so learned counsel for the petition. Mr. N. Ratan Learned additional advocate general for the state has submitted that the state has already filed their affidavit in opposition. Mr. MS So-and-so learned counsel appearing for Mr. Aringo, learned counsel
Your
for the respondent 7 to 17.
Yes, Your
Press
Honor.
for and is granted 2 weeks time to file affidavit. This after 2 weeks.
Much obliged.
Only for the one of the matter, the affidavit to be filed by the state respondent, madam. Matter is pending, madam.
My Lordship, we need some more time, my Lordship. File affidavit.
Mr. M. Kato learned counsel for the MSK, one learned counsel, state counsel Respondent is granted 3 weeks time to file affidavit.
Interim order.
2 weeks, 3 weeks.
Three.
3 weeks time to file affidavit. Interim order plus earlier circumstances.
Develop.
What is the listed for orders?
I don't have any idea, my lord.
What is it been listed for? Orders.
I don't know, my lord, why it is listed for orders.
Last 2 occasions you have sought for a time.
Yes, my lord.
Nothing is to be done. Any records?
Your lordship, yes, record was called for, your lordship.
Huh?
Record was called for you.
You have the records?
No, your lordship, this is this
Through the registry.
registry.
What about the registry? What is record? Heard Mr. B. Pitcher, London Council for the petition, and also heard MSD, the London additional PP for the state. Any private respondent? No.
No, my lord, joint application.
Call for the records. This after 3 weeks.
Deeply. नहीं मेरा है
Heard Mr. K. Nolan, London Council for the petitioner, and also MS L. Hage, London Council for the London additional PP for the state. Office note reflects the original dated 29/7/20/07/2020 reflects that scan copy of the case record is received. This for admission here after 2 days.
Right.
Office note reflects, it's,
My lordship,
oh, office was hard miss, huh? Record is not received. And Mrs. So and so, London Council for MST in report, London additional people for the state. Office note that 29/07/24 indicates that reflects that record from JMFC Pangin is yet to be received. Registry to send reminder.
not meanwhile,
Interim order was earlier. Office note dated 25/6/2020. Non appears for petition on board and Mr. Here the London Municipal is present. Office note indicates that the scanned copy of the record is received. This after 4 weeks
For admission, your lordship.
for admission.
Admission.
But Mr. A, D. Deposit. Dilip. Okay. This okay, land person for the petition. And Mr. and MS L. Haggis Swenson, huh? Office note indicated, no, record, a scan copy of the third court record is received. List for admission after 4 weeks.
Right.
Your lordship, LCR not received, your lordship.
Not received.
Not received.
But Mr. K. Lowell, London Council for the also Mr. T. at the London Edison, PP for the state. Office note reflects that, office note dated 13/07/24 reflects that record is yet to be received. Raised to send remember. Please
Obliged,
after
Your
4
Lordship.
weeks.
Obliged, Your Lordship.
Deeply obliged.
Notice to the private respondent. Basically, it's a controversy between the petitioner and the private respondent.
They're supposed to file affidavit, impleadment petition.
Yes, Lordship, connected council is also not available today, so I need some more time to file
Mr.
application.
So learned counsel for the petitioner submits that he may be granted the further time of a further 3 weeks time to file, further 2 weeks time to file appropriate application for impleadment.
Yes, sir.
Praise the Lord. List after 2 weeks. Mr. N. Nathan Lund additional. Additional advocate general for the state is present. Yes, what is this IA?
Yes,
my
I
lord,
have filed this IA for modification and vacation.
Ah,
The interim order passed by Municipal Court RDA on 6/6/2024.
This is first time.
First
Yes,
time.
I should notice.
No,
But
my
this
lord,
is
we
a
have
case-
already served the copies to the this appellants, my lord. For this IA, there is an urgency, my lord, here in this IA. We have already served the copies.
They
And-
wanted without I file reply, this should be hard.
My lord,
IA.
yes,
IA.
yes, my
filed
lord.
by him.
Yes, I have filed. I have on
File
behalf of
reply.
respondent number, my lord, 1 to 4.
It's listed for the first time.
Yes, yes, my lord.
He's appearing. He is
Uh,
accepted.
Yes, yes.
By filing this application. I heard Mr.
Bean errors.
Learned counsel for the applicant. You are respondent.
Yes, I am respondent. I am applicant in this IA.
Applicants, how many?
Yes, for the respondent number 1
Applicant-
to 4, my lord.
Applicants. This is an application for petition of the modification of the entry model. That is 06/06/2024. Passed in the affair of 03 of 2024. Issue notice.
My lord, I am praying that matter may be fixed on 5th of this August, my lord.
Not possible, my lord. We have to file affidavit in this case. After 3 weeks, my lord.
At least 2 weeks.
There is an urgency, my lord.
What is the urgency, my lord?
We'll see after 2 weeks.
Oh,
Right.
And my lord,
Reasonable opportunities should be given.
Yes, my lord.
yes,
We
my
should
lord,
be-
without my affidavit
Issue
being there.
notice. Next para. Mr. K. Brahma, learned counsel, appears an accepted notice on behalf of the opposite party.
Opposite party.
No formal notice. However, extra copy be furnished to the opposite party. In this,
And my lord, I have a prayer, my lord.
after 2 weeks.
In this same,
Mr. K. Brahma is permitted, may file.
Affidavit.
objection if any.
my lord, may
In
I
the-
pray,
in
my
the
lord?
meantime.
May I pray, my lord? In this same case, my lord, this is appeal against the order, that injunction order. Same case, same party, we have filed another revision petition.
Let's see.
My lord, in that case, the entire proceeding of that title suit number 19 of 2023 is suspended.
In
So
that
that,
case.
that may be take together with this case, my lord. That is
Please-
CRP
please-
number,
Please this letter along with.
CRP number
CRP
25
number
of 2020.
25 of 2020.
Same party, same subject, same
2020.
25 of 2024. CRP.
Take care. Take note of that. If in that case, unless you, what has to be vacated. But if even we will not be able to vacate this or modify, that is unless.
Entire proceeding is there. Highly obliged.
My lord.
Yeah.
My thing is just my appointment has been cancelled, my lord, without following the new procedure of law.
No, your appointment was rather without following due process. You said there's not an advertisement. Nothing, who knows the advertisement? Where is the advertisement? You have not annexed that also.
Advertisement.
There was no post, nothing, no sanction, no approval from the government, nothing. You being a CEO just appointed it. I mean, not you. The CEO has just appointed you.
They have
and
not,
sent it for training. Nothing.
they have not also said that there is no any pause.
Of course, nothing. It's okay.
Government has also not made out the case that there is no any pause.
We have made out. Your appointment is all reverse the rules. Not only reverse the rules. There's nothing, no post, nothing. How can you be appointed? Forget about following the rules. First, there should be a post, vacant post. Then you have to advertise. Then there should be followed by a process. Written examination, viva, and then you'll be selected, given opportunity to.
Advertisement was there. And after advertisement,
I was by the CEO, your CEO. CEO, right? He's executive officer.
yes, yes.
Yes.
So this, we have been, this May 30, in this case, it's a general municipal corporation, my lord. Seems to be, we are not furnished with the report, my lord. And this matter seems to be of 2018. Actually, 2000, it's another municipal corporation come into being after 2019, my lord.
It is after converted.
Yes, my lord.
Earlier to the IMC. Council, it is now it is corporation.
Corporation, my lord. Then I think government is contesting it, my lord. We will need this record, my lord. Copy of the petition.
2018 matter and you are not doing anything.
My lord.
It's of 2018 matter, you have not done anything in your time.
My
Where
lord.
are you now?
My lord.
Where are you now? All these appointees.
Now we're now unemployment. Ma'am.
I will take it. My lord, I may be given this opportunity to take instruction, my lord.
Next week.
My lord.
Next week, we'll take note of your instruction. You obtain the instruction in writing
My lord.
with the record,
My lord.
whatever you want to say.
My lord.
Next week,
And maybe directed to furnish me the copies, my lord.
you have the copy.
My,
Furnish the copy. In fact, it is listed for hearing.
yes, my lord. Actually, it was this service was affected only government, my lord.
No? You have sought to file a rejoinder.
No, my lord.
There are so many orders, I mean, office note that no rejoinder has been filed. With respond number 1, 2, and 3.
It's prepared by the madam. And regarding the 4 and 5, I think you have taken the ST service.
Okay, one more request. These are the person who have appointed you.
Yes.
You don't require their attendance.
My lord, I can provide my report to the matrix in my email, but client, we are not in touch with the client, so
You take an instruction, they may not be interested, otherwise, we're discussing the repetition. Next week. Not Mr. How to go, learn counsel for the petitioners. There are 3 read petitions.
two,
I think. There are 3. Just find out. One is 525. Other one is 518. Third one is 520. 520. You show it. Yes, only. Yes, one more. 520. One is LDC. Appointment of LDC. Other one is UDCs. And third one is junior engineer. Junior engineer, right?
junior engineer, but I have only two
There are
cases.
3 read petitions. One LDC, what for LDC?
One is junior engineer.
UDC, third one is junior engineer. And Mr. Odu Gonglan, concept of petition. And also her MS. Hearing for respondent number. 1. Who is for 2? IMC, you are for IMC.
I'm for IMC actually, but here it is. I have seen
1 and 3.
it is council, my lord.
Okay.
My lord.
It was not like IMC is a separate thing. Earlier it was IMC. Now it has
Municipal
been-
Council.
Yes,
That was headed by this executive.
Then it was-
Executive commissioner was the executive, my lord.
whatever maybe you find out. Whatever maybe you find out.
My lord.
You find out. So the matter is listed for hearing. And having considered the writ petitions were filed, it seems the writ petitions are pending since 2018. Well, no, though the. Not. Not technical. The writ petitions are pending since 2018. And they are listed for hearing today. Over. Mr. T. Demo, the standing counsel for Itana Municipal Corporation. Press for. Listing the matter after a week, so as to enable him to obtain written instruction as the issue relates to the then it is Itanagar Municipal Council. Presently, it is Itanagar Municipal Corporation. Having considered that the appointments were made by the authorities under the municipal, Itanagar Municipal Council back then. Which time is granted to the Itanagar Council for the Itanagar Municipal Corporation to obtain written instruction so as to and in place before this court on the next day of hearing. It is made clear that no further adjournment shall be granted on the next day. This afternoon.
Yeah, your lordship map plate. Well, in this matter, the similar matter, the analogous matter, basically, item number 57, rate petition 57. It was filed by one of the petitioner, but then unfortunately he expired. Before that, he filed item number rate petition 91.
91.
After filing 91, unfortunately he expired. And then instead of the earlier petitioner is substituted by his wife, and that's how the petition number 1 is the Adi Bomo. Basically, he's the wife of deceased of one of the petitioner who filed the first rate petition 57.
57.
Yes, and then
it's substituted in the 57.
no, we have substituted in the 91.
What about 57?
57 is the first rate petition, but we have
a pressing it.
in fact this will cover 91 and 94 will cover 57.
91 and 94.
Yes, similar, almost.
Close this necessary.
Yes, that can be almost same documents. But that can be.
Item 57. Sorry, read petition 57. Mr. Esmo, learned counsel of the petitioner, submits that. If the same issue, since the issue raised in the read petition 91.
91 is yes.
92. Different person, 94.
94. Yes. 94 is a different person.
Different area.
No, same place. But then we have in the 94 we have in
92 and 94. What is this?
91 and 94 may be hard to get.
94. 2020. 2020 are one and the same. The present petition, which was be closed, huh? Maybe closed. We consider the submission. This present reference, that is in reference, that's the item. Reference 57, item number?
Item number.
Huh? 31. Is closed. Closed and disposed.
31.
Closed and disposed. That is in item 31, right? Yes.
Yes. May Malat. Malat, the petitioners are from the villages of Singa village. It comes under Tuting circle. Now, in this matter, what happened is that some of the villagers, they proposed to give lane, the community lane, they wanted to convert into village forest reserve area. Everything starts from the Gram Sabha and Gram Sabha resolution, Gram Sabha meetings and Gram Sabha resolution. It starts from there. And on the basis of Gram Sabha resolution and a meeting, there was an agreement executed by around 10 people of the village. Who?
Just wait.
Yes.
This 94 and 92 and 94.
Yes.
Are the same area?
Same area.
Different persons.
No, same area, but a different persons.
Different person.
different person.
Same order, you are challenging same order.
Same order, same,
All meetings and
all
every-
meetings,
all
all
issues are same.
same, my lord.
Then why to read petition?
Because during the hearing, the honorable court's view was that when you are challenging the community lane, why there should be a few people? Why is the other villages?
You could have implemented them
Yes, but then we have filed
as a
separate.
petitioners.
Yes, we could have implemented, but then we have filed separate petition.
Unnecessary.
But it had happened.
Yes.
Yes, my lord.
So we're on 92.
We are on 91, my lord.
Oh, 91, sorry.
91.
Yes. So once this is decided, once we decide this.
Yes, it will be covered. Yes, my lord. So what happened was that it start from the minor sub meeting and Gram Sabha resolution. And after a Gram Sabha resolution, on the basis of Gram Sabha resolution, they have prepared the agreement. And it was executed before the JMFC Yingkyong, saying that we are donating the community lane to the forest department for the BFR. No, unfortunately, what happened was that they have done all these meetings. It was the meeting of one of the respondents who happened to be the Anchal chairperson. It was the winning meeting. But then the winning meeting was converted into Gram Sabha resolution and Gram Sabha meeting.
What meeting?
It was a
Celebration.
Anchal chairperson celebration meeting. But then that meeting was met as a minor sub meeting, Gram Sabha resolution, and then on that basis, they executed the agreement. On the basis of the agreement, the agreement was executed before the Yingkyong DMFC, saying that we want to donate lane for the BFR, and all the villages they have signed in the Gram Sabha resolution.
They've done a good thing.
Yes.
Celebration come meeting.
No, question here is that.
Enjoy bhi karo, come bhi karo.
But that was purported.
Two in one.
They purported they have.
You should encourage that. While enjoying, you should also do your duty.
But meantime, they also committed a criminal the crimes. It's offense, what I would say. They have done the force of many villagers' signatures. And then there is a separate criminal case registered and it is pending in the law court. Now, after that,
the signatures which was attached with the resolution.
yes, it is attached with the resolution. And then after that meeting, after that agreement, on the basis of the agreement, they applied before a deputy commissioner, and deputy commissioner also, based on the agreement, he has issued the mutation certificate and non-encumbrance certificate. And then preliminary notification. Earlier, before that, they have issued the preliminary notification. And then after the issuing of this two certificate, the deputy ADC of that circle, he wanted to hold a public meeting. We challenged that in the writ petition, is 91, and then it is still state. Now everything, now here, if you see the act, Panchayat Raj Act, Gram Sabha cannot be conducted by the Anchal Samiti chairperson. Anchal Samiti, that time it was not amended. Anchal Samiti chairperson has a different role. He has nowhere he can conduct a Gram Sabha resolution. Gram Sabha resolution can be conducted by only Gram chairperson of that particular jurisdictions. So there are two Gram chairperson in that jurisdiction, on that area, which falls under this line in issue. Now as we have annexed in this writ petition, both of the Gram chairperson, they say that they have declared that we have never conducted any Gram Sabha meetings or Gram Sabha resolution, which is purported to be done by the Anchal Samiti chairperson. This is mentioned in the resolution only. There is no name of the Gram chairperson. Both of the Gram chairpersons say that we have never conducted that Gram Sabha meeting or Gram Sabha resolution. We have never passed. And then there are also many, and some of the villagers also declared that there were no any Gram Sabha meeting, and how could,
Why ADC wants to have a meeting?
because ADC wants to have meeting because
Is
maybe,
it the process of
yes,
declaration?
yes, after a preliminary notification, Deputy Commissioner as a forest settlement officer, he has to conduct a public hearing.
Then why don't you have a meeting? Let
No,
the
no,
meeting
be-
go. You
because-
raise whatever you want to raise in that meeting.
No, my lord, question here is that in meeting, nothing happens, my lord. It is usually,
Will
only-
direct all to hear you all,
no, my lord, but,
have a meeting.
no, my lord, question here is that the
and then proceed.
no, my lord, hearing is only based on the mutation certificate, and mutation certificate is based on the affidavit and the agreement. And on the base
No,
of the,
that how do we know how this court will find unless that is decided?
no, no,
This is
I will
fake
show
or
you.
false document.
I will show you, I will show you,
Cannot.
I will
Because
show,
that matter is pending before the appropriate court.
no, I will show you.
Whether this is forced or not, how do we decide?
Well, I will show you, Deputy Commissioner says that it is based on the agreement executed.
No, that's what I'm saying.
Yes,
Agreement, you are saying that this is forced one.
yes.
The signatures attached to the, resolution, apart from not being properly, what meeting is called?
The minors of meeting of the Gram Sabha
Gram
and Gram
Sabha,
Sabha resolutions.
It is based on the forced signatures,
Yes,
which
yes.
you have filed in a criminal.
Because no meeting had happened. Because
No, happen or not happen, will not go into it. It's a purely disputed question.
no,
of
my lord,
fact.
I will just show you.
Now, against that meeting, apart from not properly, alleging that no, there's no meeting, the signature attached to the resolution. You are saying that it's a forced one. Who will decide that?
But my lord, law is very clear. I will just show you from the document. In the resolution, it is mentioned unchair chairperson. Unchair chairperson cannot hold the.
We're not going to go into it. Right? Whether there was a meeting or not meeting, no meeting. And whether this has been forced or not. This court is not going to determine. What will you see is.
No, I'm not talking about the resolution force or not. That is signature differently attached.
Yes.
I will just show you the
Unless the DC has relied on the resolution by assuming a mutation,
No, DC has relied on the agreement executed.
whatever. The agreement is based on the resolution.
Yes. No, thing is that the resolution itself is not valid. I want to,
Forget about that. Agreement is based on the resolution,
yes,
wrongly or rightly. In that resolution, you said you have alleged that the signatures of the questions, it's forced one.
but that is my lord, that is a different, that
Sir,
is
The
a,
basis is the resolution and the signature.
no, my submission is in other angle.
Now the agreement is based on the resolution. And the
Yes.
mutation certificate is based on the agreement.
Agreement.
The basis is the resolution and the forced signature.
No,
So that's what I'm saying. Why don't you go back, let there be a meeting, you raise all these points, and the TC will decide. Depending on the pending of the outcome of the pending cases.
no, my lord, my submission is twofold, my lord.
What criminal case is pending?
My lord,
Regarding what?
my lord,
Forgery.
in fact, complaint was filed by one of the petitioner.
Yes.
Unfortunately, he expired
Yes.
and that could not be proceeded. So that is,
Proceeded in what?
I mean, that trial could not be proceeded, but then separate complaint has been filed by one of the other,
Trial gets abet when the accused died. Expired.
but then separate criminal complaint has been filed, but then it's yet to be taken cognizance by the concerned magistrate. That is differential. But in
Is it
here,
pending before the magistrate?
yes, pending before the magistrate. But here, my lord, my submission
So
will be,
unless that your resolution and the force things are decided by the appropriate court, how do we know that this is the forced one?
no, my lord, I will not go on the force side. right now. I will go on the documents, whether document, your lordship may just verify whether this document is correct as per the law, that I will go on that. Because Gram Sabha resolution has to be as per the Panchayat Raj Act. Panchayat Raj Act. So I will just go on it as per the law. So now, if your lordship is convinced that if it is not as per the law, then it is illegal. If it is as per the law, it is correct.
No, that's what I'm saying. Why don't you go back and have a meeting? What is the procedure for declaration of the BPR?
There is two
Yeah,
options.
what is this?
Village
Village
Forest
Forest
Reserve Area. There is two process.
BFR, BRF.
BRF. That's called
Village
Village
Reserve
Reserve
Forest.
Forest Area.
Ah,
BRF. So
BRF.
there, my lord, there is two
what is
process.
the procedure?
My lord, there is two process. One is that donation. Second is that if they want to acquire, they can acquire.
Yes.
That is two.
We'll direct for that. Why is if there is a criminal case, complaint, no complaint, whether resolution or I'll direct the authorities to go as per the provisions of the law for declaration of village reserve forest area. Properly, is not it? Will not go into the whether the resolution is correct or not. That will be unnecessary because that will be asserting the power of the court below. But if this is correct or not.
Yes, but yes, but
So there is a stay of the proceedings
yes, still a
for
process.
declaration.
Yes, but
Let us see the provision.
yes,
Just
yes,
show
sir.
the
Yes,
provision. Forget
provision,
about panchayat.
yes. Provision in the sense of
For
BFR.
declaration of BF.
Yes.
That will be relevant. We'll send it back. What do you say, madam?
Lordship,
It appears
basically-
to be not clear, the declaration, they are challenging the I mean, what do you call?
Lordship, they have made the complaint after 2.5 years.
It's
This
okay.
court
What
wrote
has
the
happened?
complaint
Can you
also.
say what had happened? You have not declared it. You have not declared the area as on date. You could not complete the process of declaration.
Preliminary notification has been.
We'll direct you to do fresh.
Lordship,
Your
Better,
lordship,
is it yet to be declared?
Initially, it was more than 54,000 because of this a few complaints, Lordship. It has been made 47,000
No,
acres
this-
of acre something.
no,
And then
my lord, this is not
It's okay, whatever, maybe you do it fresh.
my lord, I'll-
As per the provision. So let us see the provision, how.
yes, your lordship may see the AP Code Volume 1.
Is there any violation of this?
Obviously, my lord,
Not
loan
obvious.
taking, my lord, I will just submit that lane in Arunachal, but your lordship is well aware of that lane in Arunachal, especially in the villages,
I don't know.
especially in the villages, is a community lane. It-
I have completely forgotten.
Okay, then I will convince that, my lord. I have the provisions. I will convince that one. The lane in the village is owned by the community. Now, question here is, in our case, only 10% has signed the donation agreement.
No,
Are they have the right to
It's
take?
okay, we'll consider that.
Yes, ma'am.
that's
I
wrong,
just wanted to
Ah,
know
okay.
what is the
Pro-
procedure?
Provision, my lord, is Assam Forest Regulation.
Yes,
It's under the Assam Forest Regulation.
1891.
1891, yes.
Yes.
It starts from the page 6, if I see the volume 1.
Yes.
And important is on page 8. What are the procedure to follow if the area is to be reserved for the forest area?
Yes.
There's in chapter 2. Chapter 2 talks about, may I read that one? Section 4. Section 4 and 5 and 6 is important. Section 4 talks about, may I read? The state government may constitute any land at the disposal of government reserved in the manner hereinafter provided. That it says the power constitute 5 subclause 1. Whenever it is proposed to consider any land as reserved forest, the state government shall publish a notification in Arunachal Pradesh Gazette specifying nearby as possible the situation and limit of such land, declaring that it is proposed to constitute such land as a reserve forest. And B, B talks about declaring it is proposed to constitute such a land as a reserve forest. C, appointing an officer therein after call the forest settlement officer to inquire in and determine the existence of nature and extent of any rights claimed by or alleged to be exist in favor of any person or over any land comprised within such limit. Any claim relating to practice.
Come to page 17,
Yes,
village forest.
yes, 17 talks.
Why you should go for those general one? This is relevant is,
Chapter 3 talks about the village forest.
yes, where on the village
Yes,
forest?
we are on the village forest. But then to convert into village forest, we have to comply the chapter 2.
It's okay.
May I read that one?
That has been, I think, you are not challenging that it has not been complied with.
Yes, my
You
lord.
have not challenging it.
No, we are challenging
You
the
are
whole-
only objecting that the resolution, it was not properly done. There was no resolution and declaration is done on the basis
But this
of.
is all part of the process, my lord. This is all part of the process.
No, you are not saying that the government has not followed this forest regulation.
Yes.
You have not said so.
No, I am challenging the whole process which the,
All process, which provision?
my lord, provision in the sense, I will just take to the 11.
Suppose,
I will
suppose
Yes.
if the resolution was done, had the resolution been done, passed in accordance with the whatever, Panchayat Act
yes.
or not,
There no objection.
there is no objection.
No objection, no.
So there was no question of section 4 and 5. We'll directly come to section 29.
My lord, I have because chapter 2 has to be followed for the chapter to convert the village forest reserve. Chapter 2 has to be followed, my lord.
Where it is?
My lord, it's written just wait, take 2.
Government may notify.
In the village forest area, may I read just one? Page 18, 18 subclause 2, 30 subclause 2. The state government may by rules declare any of provision of chapter 2 of this regulation to be applicable to the village forest. So it has to declare even for the village forest area, they have.
May by such rules declare any of the provisions chapter 2 of the regulation to be applicable to village forest.
Village forest, yes.
It's not necessary. Do you have the rules for
Lots
village
of-
forest?
Lots of PFR, yes.
And my lord, I want to take to 11, section 11. Section 11 is a page 10. Section 11, page 10, section 11, subclause, clause 1 and clause 2. I want to read clause 2. May I read clause 2, 11 of clause 2. If such claim is admitted wholly or in part, a forest settlement officer may A, subclause A, come to an agreement with the claimant for the surrender of rights.
Sir,
B.
these are for declaration of the reserve forest.
Yes.
Yeah, but
Where
that's
on
no,
the
my lord,
village forest.
my lord, it
reserve-
has to be followed, my lord, as per the clause 2.
Are you saying so? In your petition, in the present petition?
But in our
That the
petition,
state has failed to abide by comply with this provisions.
my lord, in our petition, what
There's
we
nothing. What you are saying is the basis of resolution and the process is illegal.
yes,
Force one, therefore you could not acted on it.
yes,
So we'll agree, no, we'll not comment on this, since it is a matter to be decided by the, whether this is a pause or not, whether this is a rightly resolution was taken or not, that will be decided by the appropriate forum. So we'll say, in according to this provisions of starting from section 29, you do the process afresh. Because you are not challenging in this writ petition, saying that the state has not followed chapter 2, chapter 3, chapter 4. Have you said so?
my lord, what we have said is that to convert the community lane into village forest, they could not have proceeded by purported donation, which is done by 10 persons. Whereas if the lane is a community lane, then even if there is a donation, it has to be done by the villages and with the consent and inform. But it was not done. That is this is our main contention, the writ petition, my lord. And then the resolution, it was itself is never has held. The authority who was supposed to decide the Gram Sabha, they declared that they were never conducted any Gram Sabha resolution. I will just check to that. Some
Impute orders. Let us see the
yes,
impute orders.
yes, my lord.
One by one. We'll come back to this. Madam, you go through this. Village forest, the procedure, and whether any rules have been framed under this act, regulation. Can you go through this? Section 29, starting
29.
Starting section 29. Yes. Show us.
Impugn, which the impugn order is in page 106, 108.
Just wait. (106).
Yes. 100, 106, 108. And then other impugn order is in page
108 is what?
yes, 108 is preliminary notification, my lord.
You know, it is for journalists all public of single and we do favor village forest with area of forest and municipal.
7 and 8 is the preliminary notification.
They are fixed in the conference on medicine. Only yes. This is for GBG public stakeholders, including you. Then this is preliminary notification is before that. 2018.
Yes, my lord.
Yes. Why you are challenging this?
My lord,
this is after the resolution and the mutation.
yes, my lord.
Okay, then
Next is 106.
First is 106. Then next is 107.
7 and 8. And then we are also challenging the it's impugned mutation certificate and non-incumbent certificate, page 45 and 46.
Where it is
45 and 46.
45
and 46.
page 45 and 46. This is certificate by Deputy Commissioner.
Deputy Commissioner, my lord.
Ah.
And next impugn is, my lord, sir, is in page 30. 30 is the Gram Sabha resolution held on 6/11/2013.
This is 45 and 46 is
45 and 46 is a certificate, mutation certificate and non-encumbrance certificate issued by Deputy Commissioner.
okay. Then
resolution is in page 30.
Gram Sabha.
Yes, and agreement is in page 31 and 32. And 32, my lord.
Yes. Then
Now I want just to show resolution in page 30.
Hmm.
30.
hmm.
Page 30 is
Yes.
your lordship may see
On the basis of this resolution and the agreement, this
On the
DCL
basis-
issued the mutation
Certificate.
certificate and the non-encumbrance.
yes, my lord.
All right.
So now I'll just
Then
point
then
out
this is of 2013 and this 2015 And then 2018 is the
Preliminary
preliminary
notification.
notification and
Yes.
2020 is for the
The hearing, public hearing,
meeting.
meetings, public meetings. I'll just point out this one, page 30. Page 30, bottom right. Here it is mentioned, Monge Melo Anchal Samiti, Anchal is Anchal chairperson.
It's okay.
Yes, my lord. And then
So according to you, this is not a resolution. In fact,
as per the, this is usually, my lord, Gram Sabha has to be conducted by the Gram chairperson,
Gram chairperson, this is conducted by
by Anchal chairperson.
Anjal chairperson.
So I want to just take to that law.
And the annexes, I mean, the signatures attached to the resolution are
Yes.
forged.
Yes, that's what.
That's all. Therefore, it cannot be taken as a resolution
Resolution.
by Anjal chairperson,
Yes.
not by the Gram chairperson. What are you saying?
Not by the Anchal chairperson.
Ah.
It should, resolution, any Gram Sabha meeting has to be conducted by only Gram chairperson. I will just take to that, law.
It's okay.
I will just, only just provision, I want to show that provision.
Anjal chair. Anjal is higher.
Yes, Anchal is,
than the,
Anchal is above the Gram,
chairperson.
Gram.
Yeah, above the Gram chairperson. If
So I'll-
Anjal takes up, what's the wrong?
My lord, just may take to the volumes 8. Volume
Yes.
8, volume
Just
8,
read it, just read it. Section,
section 7.
yes.
Section 7 talks about the Gram Sabha meeting. And it has to be chair presided over by the chairperson of Gram Sabha. Gram Panchayat. Chairperson of Gram Panchayat. And then
Gram Panchayat includes the Anchal Panchayat. Anchal chair.
Anchal has got different functions as per the act.
No, Gram chairperson, Anchal, they have the
Different function.
But then chairperson should be the Gram Panchayat includes the Anchal chairperson.
Well, there should be 2 meetings as per the act. One is a Gram Panchayat meeting.
For what?
Gram is a meeting of,
Constitution of the.
no, even any special resolution which
So when they will say is the chairperson of the Gram,
Yes.
Gram chairperson has to conduct a meeting for the purpose of this.
no, there is no provision.
Then
Because Gram Sabha resolution is only through the Gram Sabha.
when it says that the Gram Sabha resolution is required under this regulation.
Basically, Gram Sabha resolution is for they try to show that all the villagers are present and we are giving donation through the Gram Sabha meeting. That is, they wanted to show in that way. They have made the documents, my lord. Otherwise, there is no any as per the provision. It doesn't talk about the Gram Sabha resolution. But then they have met as if there's a public meeting through the Gram Sabha, and through Gram Sabha they wanted to donate the land for the BFR. And my lord, the land is not a small, my lord. It is 400. I just made 470. I just made to take to the that mutation certificate will show the total area 45. My lord, the area is not a small, my lord. This whole village, the Zoom area has been converted into BFR. It total is a 476.20 square kilometer, my lord. Almost all the locations are from 3, 4, 5 villages. Almost area has been
So
converted to
nothing
BFR.
has been done as of that.
Yes, nothing has been done as of that.
So
It's a big loss for the villagers, my lord. Because once it become a BFR,
Madam will direct you to do a fresh involving all the stakeholders, including the petitioners.
because it will be a great loss for the villagers, my lord. Because once it, because
See, if it is declared, certain benefits will go to you.
yes. No, but then there has to be clear about the boundaries. Land belongs to whom? There has to be a public consent.
Obviously, these things will be taken care of.
This is community
There-
land.
there have-
Suppose, see,
Community land,
yes,
not-
see,
not
there are
individual land.
47 or 50,000 square, I mean, kilometers or whatever
Yes.
areas. That will be, they have mentioned here.
No, my lord, question here is my lord, I am in a village, and if once my area is converted into a BFR,
That's the reason you cannot object to it. See, reason is very simple. Declaration of the reserve forest is a different thing. Altogether different. But constitution of the village reserve forest is something else.
no, my lord,
It's a different-
I may just
Altogether different.
may I just clarify that one, may try to convince your lordship. My lord, BFR and BRF, that's called village reserve forest. It talks about if it is converted into a BFR, then as per the provision, it talks about 50% revenue go to the village and 50% go to the forest department. But here, my lord, in that with the area which is been going to declare the BFR is completely 100% tree
That's why
tree covered
we
area.
direct them to redo it afresh
I mean, just
in
want to,
accordance with the regulations
yes.
and the applicable rules and act.
And now, what happened is that not only in that area, Singa area, it has been done in different, even in my village.
Forget about others. We'll
Yes, my lord.
concentrate on this.
So the question here is, my lord, once it become a BFR, my lord, I cannot do any economical activities or for any development in that particular area, because once it is a BFR, whether BFR or the forest reserve, it's almost equal, my lord. And another question is that the BFR which they wanted to convert is 100% covered with the trees. But as per the definition of the forest department, they are saying that it's a degraded.
Where is the Arunachal Pradesh Unsel Reserve Forest
Yes, my lord.
Constitution and Maintenance Act 1975? And this for the Arunachal Amendment 1984.
I think it's actually with the volume 14. Volume 14 is amended. And Anchal has been substituted with the village forest reserve area in 2018. I may just take to page 63.
63.
Page 63.
Yes.
Section 27, it talks about merit. In section 153, the word of Anchal Committee or the Anchal Committee, the Central Committee shall be deleted. And another malat, I want to take to section 22. It talks about Gram Panchayat. Anchal has been substituted with Gram Panchayat. So even in the act also, it has been substituted, malat.
To a village forest.
Yes, village forest union. I want to take.
Unsel Cemetery and the Unsel Cemetery shall be deleted. 153. This is Panchayat Raj Amendment Act. Why you are taking to us this Panchayat Raj Amendment? I'm talking about Arunachal Pradesh
Yes.
Unsel Reserve Forest Act 1975 and the Amendment Act of 1984.
I have only amended 19 volume 3. Volume 3 is
Arunachal Pradesh Unsel Reserve Forest Reserve Act.
1975. Yes. You have that. The Amendment Act is there. 1984 Act. It's an amendment only. 1984. Amendment of 1975. You have that 75.
75.
75 you have.
Yes.
75 I have.
And 84 Amended Act.
84.
Same act amended
84.
75. Let me see.
84, yes, yeah, 84 in volume 4. 75 talks. '75 is talking about constituting of Anchal Forest Reserve area.
That is important.
But then it has been
Why you are taking us to the unnecessary of Panchayat Raj.
Yes. My lord, page 2, my lord. Page 2.
Yes. Of what?
Page 2, section 3 of volume 3.
84 amendment.
This is not an amendment, my lord. This is volume 4, volume 3. My lord, this is the act, my lord. Arunachal Pradesh Anchal Forest Reserve Constitution and Maintenance Act 1975. Section 3. Section 3 talks for, my lord, the power to constitute Anchal Reserve Forest. But in this page 2.
Page 2.
Yes. Page 2, section 3. Section 3 merit.
Yes.
Clause 1, the state government may, or by notification in the official gazette, constitute any lane reserve at the disposal of the government as Anchal Forest Reserve in the manner provided in chapter 2, my lord, of Assam Forest Regulation for the constitution of Anchal of reserve forest. 2, only economically viable units of land shall be constituted into Anchal Forest Reserve area.
Any rules? Any rules made under this act?
My lord, rules, my lord, don't have, my lord.
What is the amendment?
Amendment, yes, my lord. I will just take to back to the amendment. Amendment is in the volume 4.
84.
Volume 4.
Yes, 84.
Yes, 84.
What is the page?
Page, my lord, 113. May I just read section 2? Section 2.
Yes.
In the Arunachal Pradesh Anchal Forest Reserve Constitution and Maintenance Act 1975, hereinafter referred to as the Principal Act, in the title, after the word Anchal, word and village shall be inserted, my lord.
Instead of
Anchal, village word will be inserted.
Village.
Yes, my lord.
Okay.
Village word will be inserted. And then, my lord, section 5. Section 5 also important, my lord. In the Principal Act, after section 3, the following sections shall be inserted. 3A, the state government may by notification of it constitute any lane other than reserve forest at the disposal of government as a village forest reserve. Page 114. It starts from 113. Village forest reserve in the manner in chapter 2 of the Assam Forest Regulation 1891 for the
section
5. Section 5.
State government may not be any land other.
They have to follow chapter 2 of Assam Forest Regulation.
Yes. Five ways is provided clearly.
And section 8. Section 8 talks about in subsection 8, 115.
Yes.
May I read? In subsection 2 of the section 6 of the Principal Act, in a clause A, for the word Jila Parishad, the word Jila village panchayat shall be substituted, and for the words Anchal Reserve Forest, word Anchal Forest Reserve Area or village forest reserve shall be substituted. So the BFR is clearly mentioned. That's all. So
Will directly constitute it by following the rules and act and rules afresh involving the, obviously if it is in accordance with rules and act includes hearing all the stakeholders, including the petitioners. Otherwise, the resolutions and all other things, if it is, it's a creates a doubt, and they have filed a criminal complaint which is pending before the appropriate court. So we'll not go into whether this is correct or not. We'll just skip that. We'll not comment on it. We'll say that you go by the act and rules in accordance with act and rules. Then you will have to issue preliminary notification. I mean, you have to obtain all this resolution. It will be, we'll not comment on the veracity of this resolution. Because wrongly or rightly, they have made a complaint. May be correct, may not be correct. That will be decided by the appropriate court only, is not it? What do you say? You are for?
That is, respondent number 9, that is correct.
Respondent number 9. Because we unnecessary, if we cannot keep it waiting for them to decide,
Yes.
then whether is the complaint, I mean, whether there is a fault, not fault. You have a, do it fresh.
I think.
That would be better.
Yes.
Otherwise, wait, to decide it, we'll have to wait for that
Yes.
decision of the
No,
trial of the matter.
Right.
because
See,
that,
don't let us not have, you just see the preamble of the act.
but my lord, land which has been acquired,
Provide for constitution and maintenance of until reserve forests in order to do the other matters connect. It is expedient to constitute for the benefit of people of Arunachal Pradesh. You'll get, I mean, the whatever the private ownership in the areas, that is something different to be looked into.
No, so this is not
This is a community land.
community land, yes.
You are not getting, you'll get the benefits out of it. If it is constituted, at the same time, it's a preserving the
Yes.
ecology and environment.
my,
That's why it has been made.
my lord, in fact, this is my lord, my submission will be different, my lord, because the lane which
We'll
is,
submit, we'll record your submission.
my lord, otherwise really prejudice will done to the landowner, especially.
Whatever the other people, you are not the
Even-
only people. Are you the are you the owners of the land? The petitioners are the only owners of this land. There's no other persons other than you. The
But my lord,
petitioners.
everything has generated from the regulations. Now,
Forget
regulation,
about it. Why not comment on it?
now regulation is done by the,
Heard Mr.
Irrigation only, Lord.
What is, what you have said, you have justified your,
Resolution,
yes, where it is, your affidavit.
yes, Lord. Regarding resolution,
Where is your affidavit?
yes.
Affidavit in,
my lord, I will pray
Yes.
that, my lord, it can be sent back fresh that your lordship has already proposed. So I have no any objection that
Yes.
today, that I will. Because that will be fairly, because when the fresh is done, the at least hearing will be done to the villages. Otherwise, in this case, no opportunity was given to the villages. Only the few people have decided that we want to give donation, my lord.
That is not said. We are not accepting that. We have denied that. We are saying the Ansal Committee is the overall Lordship governing body of, for a number of Gram Sabhas in a Ansal. So Ansal chairperson Lordship.
And
is the
Gram Sabha, my lord, I have.
yes,
I will propose that mallet can be sent back because whatever they have done is without informing the villages, only the few villages they have decided. So if the whole village they want to give that their own possessed land, then we don't have any issue. So that at least that can create a fair proposition to the villages also. my lord.
apprehension.
In
Yes. Because in case in the present case,
Para nine.
In the present case, my lord, only the 10 people have decided as if it was the, they are representing the whole villages, my lord.
There are 8, 9 waivers of it. Explain everything in para 8 and 9, 7, 8, 9. Para 9, we will have said that perfect. There are 9 dates and also. In 91 also. In 94 also, we have, in our affidavit, we have covered all the lots of allegations also.
Initially, it was 54 something hectares. Now then 7,370 hectares have been
Reduced also.
excluded.
My lord, not 50, my lord, it is a
Now
Area
it's 47,000.
54,000, my lord.
54,993
Yes.
hectares initially.
It has been reduced to 47,620 now. Because of lots of. For the.
No, this was the agreement, my lord. But then the reducing and everything, this is, it has been done on the wish of the, this one. Authorities, my lord.
Only.
And my lord, it is not a small area also, my lord. At least fair hearing should have been given to the village, my lord. That is my proposition, my lord. Because this will really prejudice and it will really great injustice will be done to the villages, my lord.
And lots of the petitioner is talking about the lots of section 2 of section 5,
Because-
subsection 2 of section 5 of Assam Forest Regulation lots of 1891. Deputy Commissioner lots of, not Deputy Commissioner. Deputy Commissioner has appointed lots of DFO as Forest Settlement Officer.
Yes, suppose if the resolution is taken
Yes.
as required to be done under the Panchayat Act, do you have any objection?
No, I have no objection then.
Then
If it was done rightly, but then resolution
just
is,
that you were not there in the resolution, Gram Sabha meeting.
no,
You are objecting.
because Gram Sabha resolution never had happened.
No,
Another,
suppose if it is if it had happened, had it been happened with the under the act or as
Then
desire
I-
or
then I think, my lord,
in your presence, you have no objection.
then I would not have come
For
in the court.
declaration and of village forest,
Then, my lord, I would not have
village
come,
reserve forest.
then I would not have come in the court, my lord.
Then
Because my
you are
whole,
not saying that by declaring or having a village reserve forest, you are totally disentitled. I mean, deprived of your right of the land.
yes, my lord.
Initially, you are trying to project that. But if it is, if the resolution is taken, including you, or as per the, I mean, according to, if it is by the Gram chairperson or chair, I mean, of the Gram Sabha, you would not have any objection.
But then there has to be a boundary, has to be clear, because there's it's a, my lord, community land means it divided among the clans. Here, there are many clans. No one knows which boundary, which area has been given for the BFR. It is completely ambiguous. No one knows which latitude, language, which bound, from which boundary, from which clan.
Notification is there.
But because, my lord,
You see the preliminary notification.
no, my lord.
What is your language, everything is given.
No, my lord,
Read your preliminary notification, 108, 107.
but my lord, villages were never informed, my lord. That is my whole
Well,
submission.
just now you said there's no nothing, latitude, language, it's given in preliminary notification.
No, it is there, but then villagers, they don't know which area has been given.
That's the reason the resolution was, on the basis of the resolution, you have the knowledge of that.
My lord, another is the resolution is, basically it was never there, my lord. That's what in the beginning I have submitted that. It was a party meeting
It's
of
okay.
the.
Then
My lord, resolution, my lord, as per the Gram Sabha, my lord, resolution is in, section 6. Section 5 talks about resolution, my lord,
of what?
of, Panchayat Raj Act. If resolution has to be done, it has to be done by the chairperson, my lord.
We're not going. We'll not go with the resolution, I mean, the act of the Panchayat, I mean, provision of the Panchayat Act. We'll go by the forest conservation and all this.
Yes.
So forest conservation,
regulation,
forest conservation, my lord,
not conservation, forest regulation, Assam Forest Regulation as well as the 1975 Act, Constitution and Maintenance.
that also, my lord, there is a two-way, my lord. I was trying to read that, volume 1, 11, section 11, my lord.
Yes.
Lordship, in page 12,
Volume 11, section.
in my affidavit in page 12, in one of the para, we have said that Natimiku, Lordship, is a habitual offender and does not have any land in the proposed Idu Deba village forest, which was forwarded by
Page,
Lordship 12, we have said,
para 12 or page 12?
page 12, Lordship,
Page 12. Go.
Roman 2.
Para 12, para?
Page 12,
Ah,
Roman 2, Lordship.
para Roman 2,
Yes,
where it says,
it says, Lordship, Roman 2.
what it says?
3518 address to PCCF Court of Appeal against Natimiku himself requesting for early public hearing of actual land orders while alleging that Sri Natimiku is a habitual offender and does not have any land in the proposed Idukeba village reserve forest, which was forwarded by APCCF, Tanagar Environment and CC and Nodal Officer FCA to Deputy Commissioner in Modification. And then later also we have an annex also.
My lord, your lordship has read that, if the forest reserve or Anchal, reserve forest of BFR, they have to follow chapter 2 of the Assam Forest Regulation. And Assam Forest Regulation, it's clear.
Para 13 lordship, which
Assam-
followed lordship.
Assam Forest Regulation clearly, it talks of section 11, clearly talks about there has to be, the one is that, they have to follow procedures, my lord. So our allegation also the procedure not follow, my lord. As per
What
the Assam Forest.
procedure is not followed?
Yes, my lord.
What procedure is not followed?
Section 11, which, the power to acquire land over rights as claimed. Section 11, Section 11, clause 1, clause 2.
Is it your pleaded case? Is it your pleaded case?
Yes, my lord.
Where it is, where your statement,
By that one.
what is your statement that is, that this has not been followed?
Page 13, paragraph 13, we have said that we have followed the lordship, whatever the procedure and the forest regulation and BFR also. While issuing preliminary notification, we have said we have followed.
How many petitioners here?
My lord, here, my lord,
9, and in
9 petitions, my lord.
And in 94,
In 94, my lord, petition.
'49. '49 plus 9, 58. What is the population of that area?
Population, my lord, Singa area, my lord, in 94, I think we have mentioned somewhere in should be
What is the population, Singa area? Only 58% are before this court,
5 villages.
Yes, it's partially populated, my
Four
lord,
villages,
not much populated, my
only 58.
not 58, should be more than that, my lord. Small villages, a hamlet, small villages.
It's around at least 400 to 500.
Should be 4 to 500. Population, I think we have not mentioned it anywhere. Especially in our villages, especially there are not much, even one family also can become a one village, especially in our place, especially in the Bang Valley. Around 200, I think, approximate, I think. So that's
So only you are 58. Democratically, you are minority. You cannot install it.
But an agreement was done by only 10%, my lord.
Hmm?
Agreement was executed by only 10%. The 10 people. I'll just show the agreement, my lord. My lord, agreement is in page 31. 31, my lord. The total number of person is in page 32. Only 10%, 10 people, and then
Representative capacity,
countersigned by 4%, my lord.
maybe representative capacity. With the Ansal Committee members, Gram Panchayat members, Gabura, and other villages of Idu community of Singa village, the meeting of Singa community on 6th November, Union decided to permit volunteer to the Department of Municipal Forest and the Engineering Forest
Lots of in WPC 94, what we have stated is that this was a degraded forest and it has hardly any economic value. The scientific management will improve the economic as well as ecological value of the said land in question. Okay. 94. WPC 94. My paragraph 13, 14 maybe was looked into. The resolution was.
The deed of agreement is before the judicial magistrate first class.
Yes.
Yes.
But the person who
So
are
what is the resolution is to be adopted by the Gram Sabha in the either Assam Forest Regulation or
Panchayat Raj, I can show you that. Assam Forest as per this,
or the maintenance Constitution, the Maintenance of Village Forest Act 1975.
my lord, as per this volume 1 is Assam Forest Regulation, my lord. Only the chapter 2 has to be followed. My lord,
There is no requirement of resolution by the Gram Sabha.
no, there is no any resolution. my lord.
Then, and under the Act
Under the act, there is no any
75,
75, my lord.
is there any requirements under the Act to have a village Gram Sabha resolution?
That part exactly, I do not know. What is the process? And our contention is otherwise also. It is, we have seen in this WP number 57. Our contention.
That has been closed. You write
In this case,
make submission 91 and for 94.
94, in this regard, respondent number 8 has filed affidavit stating that
8 or 9.
8 and 9 is.
No, are you 8
Out
or
of-
9?
Yes.
My lord,
This nine. Respondent number 8 in the.
94?
Petition number 94.
well,
In this
until
case,
this one act, this act, Anchal Arunachal Pradesh Anchal Forest Reserve also, they have to follow chapter 2 of Assam Forest
It's
Regulation.
okay, but
Yes.
where's the requirement
Resolution
of-
nowhere,
resolution of the Gram Panchayat?
There is no
So
Gram
we
Sabha
should- we
resolution.
should enter into it. Donate,
Only,
it has been donated by the all these Gram Panchayat members, Gaon Buras, ex-ACM, ex-JPM, public leaders in other villages.
but this is, my lord,
Your basis is that until the proper resolution is adopted by the Gram Sabha, it cannot be declared. It cannot be constituted. That is what you are saying.
my submission is that this so-called
Agreement.
themselves as a leader, they cannot represent whole community, my lord.
Now, what about the this thing, agreement?
My lord, agreement, yes, that's what, my lord, I wanted to point out is
See,
that.
certificate of mutation is not also, it doesn't also talk about the resolution. Community hall on 6th. Yes, yes.
My lord,
Of
Well,
course, it talks about the resolution. 611
6,
donation. I mean, the agreement, deed of agreement.
because this agreement is represented by only 10 person. So the
10
community,
persons, they are Gaon Buras, Panchayat leaders, Panchayati members,
they are all,
Panchayati Raj members.
my lord, as per this document, it shows the X, my lord, X, ASM, X, JPM.
See, with the
EPC.
answer committee members, Gram Panchayat members, these were the present.
No, my lord, may see,
And then Gaon Buras, ex-ASM, ex-JPM.
yeah, Lordship may see page 32, my lord. Here the name of the person who have signed this agreement. One is a ACP, I'm not able to understand, Anchal chairperson. Second is ex-JPM. Third is ex-ASM. Fourth is a
Then
PI.
is Raju Umbre, GPM, Ripur Boli, Deputy FR, Yamuti, GPM.
So only few groups should represent the represent the whole community, my lord. Because community in constitute of clans, sub clans, my lord. Suppose one is a Umbre, Melo, here Umbre, Melo, and then Menjo. So there's a Menjo families, Menjo Umbres, my lord.
So there is no requirement of having a panchayat resolution. But problem is deputy commissioner has taken the basis of the resolution,
Yes, my lord.
which is culminated into a
Yeah.
issuance of
So it's non
mutation
non-encumbrance
certificate.
mutation and non-comprehensive.
He could have easily issued by having a separate agreement without resolution. Yes, what do you want to say?
Lordship, I wanted to say, in our affidavit, it is out of 50 petitioners in the WP number 94, only 9 petitioners are genuine petitioners, and others are petitioners from other Divang Valley area. They are not connected with this community then. That is a point.
Who are the petitioners number, 9 petitioners?
9 petitioners. 9 petitioners is, can you see, Asone Mie is correct. Mrs.
Where you have said?
Mehta Ambere is correct. Rahul Mena is correct. Mrs. Ijunie Ambre is correct. Miss Mato Miku is correct. Mino Wala is correct. Jomku Miku is correct. Ahole Mena is correct. And Nangku Embre is correct. That is the 9 petitioners, only 9 petitioners. Another
9 petitioners in
and rest of the petitioners.
all the including 91.
Yes.
And writ petition 91.
No, in fact, we have
94.
filed a rejoinder.
And
my lord.
94.
We have filed a rejoinder and we have
One-
clarified
Yeah.
that they are from that villages, my lord.
And one of the petitioners is a refugee.
This is their allegation, but we have filed.
Refugee cannot have any land here. There is
No, they are not
specific
refugees. They are permanent residents of that village, different
One-
Tashi Gaon and many different villages, my lord.
One of the petitioner's name I have here,
This is in our regional, my lord. We have filed clarified the regional.
Dorji Dondu. Dorji Dondu cannot be a petitioner. He do not have any community
We-
land here. By way of agreement traditionally with the Idumismi community, there was
No,
agreement.
this is
Therefore, he cannot be a petitioner here.
this is a wrong submission, my lord. We have clarified in
Anyway, I will
the
not-
our
let us not
rejoinder.
travel into all these things.
Yes.
Will
That is-
direct
that is
you
my
to,
limited submission. They
yes,
cannot be a
direct you
petitioner.
to.
We have filed rejoinder and they have not
constitute a-
controverted.
In accordance with the law.
They have not controverted, my lord.
Because he doesn't have the right to file a replication
Yes.
in writ proceedings. We'll continue, that's all.
That's
We'll
all, my lord.
continue at 2.
Two.
This dictation. No further argument. Listen the dictation at 2. Dictation at 2.
Obliged.
How many matters? Huh? Okay. That case, we will see. Item 13. Where is your name? Right, item 13. Show his presence on behalf of Esquire, huh? That's why I told you, we have noticed that. Where is the requirement of meeting? Where is the meeting, requirement of meeting? It's okay, we'll not interfere, we'll not go into all this thing, we'll direct it for. we'll- Press, proceedings. Press proceedings, yes. No, no, it's okay. Problem is, there was the resolution by the Gram Sabha. On that basis, agreement was done, donating the land. On that agreement only, the mutation certificate was issued and the non-encumbrance. On that basis only, prior notification, everything was issued. So the basis is under cloud, what is to be done? Will not say, they will not set aside all this thing. Will not set as such, will not comment on the veracity of all this thing. Let it be what is there and what is not there. But you do a press process. Yes, okay. Heard Mr. S. Learned Counsel for the petitioner. Both is writ petition, huh? 91 and 94. And also heard MSG at Learned Additional Senior Government Advocate appearing for respondent number or respondent number 1 also 1, 2, 1, 2, 3, 4, 5, 6, 7, 8, 9, 7, 8 and 9 all officer in charge and Mr. T. Tapak appears for Learned Counsel for respondent number 8 in writ petition 94. Next paragraph. The petitioners claims to be residents of different villages of Singha Circle, SING, Upper Siang District, Arunachal Pradesh, have filed these two writ petitions assailing the veracity of the Gram Sabha resolution dated 06/11/2013 and deed of agreement executed on 09/12/2013. List of the petitioners have also challenged the consequential nutrition certificate and non-encumbrance certificate dated 30/10/2015 issued by the Deputy Commissioner list of the challenge is also made to the preliminary notification dated 05/110/2018 for declaration of Idu Keba Village Forest Reserve within bracket hereinafter referred to as VFR for an area measuring 47620 hectares. List of the further challenge, hectares, where it is. No, forget it. Where is this preliminary notification? One zero seven. 107. Yes, 17620 hectares. Kilometers is 476.20 square kilometer. Same thing. Issued by the preliminary notification, issued by the Principal Secretary within Berken Environment Forest dated 05/10/2018. List of further challenge is also made to the order dated 11/03/2020 issued by the Additional Deputy Commissioner, Tuting, Upper Siang District for public hearing for the purpose of constitution of BFR. List of before that, the issue involved in these writ petitions are identical, not identical, are similar, same are being taken up for same are taken up for hearing and disposed of by this common judgment and order. Then you write next one. The petitioners contents, the petitioner have projected that on 06/11/2013, a resolution was adopted by the Gram Sabha meeting and decided to declare the community land as BFR for an area approximately 54993 hectares of land in the single circle under the chairman of the respondent number 8 within bracket in writ petition 94 of 2022 bracket closed. List of. It is alleged that the signatures of some of the members were forged and some of them were made to sign under wrong influence to obtain the documents from the authority for issuance of preliminary notification of Idu Keba for constitution of BFR. List of. Pursuant to such alleged illegal resolution, a deed of agreement was entered. A deed of agreement was prepared by some persons numbering some person 10 in numbers by dated 09/12/2013. List of. Basing on the said resolution and the agreement thereafter, the Deputy Commissioner by dated 30/10/2015 issued a certificate of mutation and non-encumbrance certificate stating that an area of 47620 hectares of degraded Idu community land as Singa under Singa Circle in Upper Siang district has been voluntarily donated by the villagers of Singa village to the Department of Environment and Forest Government of Arunachal Pradesh for the purpose of constitution of village BRF dash protection of wildlife page 45, just this wildlife. What is this NAT properties? Page 45. What is NAT? Yes. Certificate of Nutrition. You forget it, for the purpose of Constitutional Village Reserve, BRF, huh? Full stop. Next paragraph. Thereafter, the principal secretary within bracket environment forest bracket close government of Arunachal Pradesh by order dated by preliminary by dated 05/10/2018, a preliminary notification was issued under section 3 capital A of Arunachal Pradesh Ansal Forest Reserve within bracket Constitution and Maintenance bracket close Act, 1975. And its Amendment Act, 1984. Read with section 4 and 5 of the Assam Forest Regulation 1891. By proposing to constitute the Idukaba BFR for an area of 47620 hectares in the at Singa village under Singa circle of Upper Siang district. Next paragraph. The additional deputy commissioner, Upper Siang district, Tuting, has issued an order dated 11/03/2020 calling for a meeting inviting all the head GBs public stakeholders falling under Idukaba BRF, proposed Idukaba BRF, and to file claims and objection for construction of the BRF, for constitution of the BRF, said BRF. Please stop. Thereafter, nothing had happened. Next paragraph. Then you approach this court, and then court has stayed. Please stop. Next paragraph. Mr. Sunil Esmo, learned counsel for the petitioner, submits that having come to know of the act of fraudulent on the innocent villagers who has filed this complaint, Who has filed this complaint? FIR. Who has filed? Page 110. Who are they? No, not some. Then forget it. It is contended that you delete the last entry. No? The villagers, some of the villagers, these are the petitioners also. Yes, some villagers numbering 18 numbers filed an FIR, filed a complaint for registration of the case before the Superintendent of Police of Upper Siang District, Yingkiang, alleging the act of fraudulent on the as the resolution was taken illegally under the chairmanship of Council Committee, and the agreement thereafter, an agreement was entered into whereby the land of the villagers was donated for constitution of the Idukaba BRF. Thereafter, a complaint was also lodged before where it is? Before JMFC Yingkiang. Huh? Where? So what is the stage? What is the stage of? Okay. Which is pending trial before the judicial magistrate, JMFC Yingkiang. Please stop. Next panel. The Mr. Esmo, learned counsel for the petitioners, submits that the holding of Gram Sabha. No. The submits that the resolution passed pursuant to the alleged Gram Sabha has not been, is not in consonance with is not as per the provisions of Panchayati Raj Act 1997, provisions under section 7 and 8 of the Panchayati Raj Act 1997. Please stop. He submits that such resolution of the Gram Sabha is required to be shared by the by the chairman, chairperson of the Gram Panchayat, and not by the Anchal chairperson. Please stop. the resolutions clearly reflects that the said Gram Sabha was conducted under the chairmanship of the Anchal chairperson. List of that effort, the members shown to have present in the Gram Sabha, the signatures of the members shown to have attended the Gram Sabha are all forged. Which amounts to an act of fraudulent on the innocent villagers. List of. Since the he submits. Since the agreement donating the land for constitution of the Idukeba BRF is pursuant to the illegal resolution, that too signed by only 10 members of only 10 persons would not have any validity. List of. Next one. Mr. Mo, learned counsel, submits that the basis of issuance of certificate of mutation and the non-encumbrance certificate by the Deputy Commissioner, Upper Siang District, is the illegal resolution and deed of agreement, the such certificate is void and cannot be acted on. He submits that the subsequent proceedings of issuance of preliminary notification dated so and so, you just mention all those resolutions and date and all, which you have given initial. Encumbrance certificate, mutation certificate, and preliminary notification dated so and so. Just preliminary notification 05 dated 05/10/2018 and calling for meeting to file claims and objection are also non-est and cannot be acted upon. List of. Mr. Next, ESMO Learned Counsel further submits that the constitution of BRF will deprive the landowners in the Singa area, as once the BRF is constituted on the land, the villagers, including the petitioners, shall not have any right to cultivate and use the area which will deprive the, which will infringe the right of the villagers and shall affect the sustenance of the villagers in general. Therefore, it submits that the entire proceedings, including right from the Gram Sabha up to the last impugn order calling for meeting and claims and objection are not sustainable and may be set aside in court. List of next para. On the other hand, not other than, per contra, Mr. M.S. G. at Leonard, additional senior government advocate. Additional senior government advocate. While referring to the affidavit filed on behalf of the state, submits that the resolution dated so and so, huh? You remember? Are by the members of the Gram Panchayat. List of the it has no relevance whether the members attended, whether the Gram Sabha was conducted under whose chairmanship. List of. It is suffice that if the members of the Panchayat have attended the Gram Sabha and passed the resolution, same can be legally accepted for the purpose of such resolution. List of. Pursuant to the such resolution, Gram Sabha resolution, the an agreement was entered into, an agreement, deed of agreement was made. Duly signed by the, who are they? Gaburas, where it is? 45. That you are attended by 49 persons, huh? Anyway. By the Ansal Committee member, Gram Panchayat member, Gaburas, ex-ASM, ex-ZPM, public leaders and other villagers of Idu community of Singha Circle. List of. The agreement clearly reflects the agreements and sorry, by the please by the agreement, it is unanimously decided to donate 54933.0 hectares of degraded community land voluntary to the Department of Environment Forests for the purpose of protection of wildlife and natural properties of the area. List of. It is also for the and also for implementation of beneficial central oblique state schemes or projects, including compensatory afforestation and the Department of Forest, Government of Arunachal Pradesh has been authorized to notify the BRF over the said area by constituting a Idu Keba BRF. Pursuant thereto, the Deputy Commissioner, in accordance with the requirement, has issued the certificate of mutation and non-encumbrance certificate on 3010/2015. List of accordingly. The preliminary notification was issued on 5/10/2018. List of. Thereafter, the Additional Deputy Commissioner, Upper Siang District, Tuting, by the order dated 11/03/2020, has invited for a meeting calling all the head GBs, public and stakeholders, requesting them to attend the meeting and to file claims and objection for constitution of the Idukeba BRF. List of. Next para. She submits MSG at London Edition Senior Governor submits Submits, then you write, you quote this para 7, 8, 8 and 9, 8, 9 and 7, 8 and 9 of affidavit of respondent 3 and 5. Then paragraph 24. 24 in Paragraph 7 and 7, 8 and 9 of WPC 91 of 2004. Affidavit of petition by respondent number 3 and 5. And paragraph 24 of WPC 90. Other writ petition. 24, right? Yes. We'll just relevant one. We'll take the relevant one. That's all. Next paras. MSG at Learners. Additional senior government advocate. Submits that there's no illegalities in the process of declaration or constitution of the Idu Keba village BRF list of. She submits that the petitioner, except for violation of Section 7 and 8 of Panchayati Raj Act 1997, which is not relevant for the purpose of constitution of BRF, have not been able to show any violation of any provisions of the Act of this Arunachal Pradesh Ansal Forest Reserve within brackets Constitution and Maintenance within bracket Act of 1975 and its amendment Act 1984 or any provisions under Assam Forest Regulation Act 1891. Therefore, she submits that both the writ petitions are liable to be dismissed and the responding authorities may be permitted to complete the process for constitution of Idu Keba BRF in accordance with the law. Next paragraph. Mr. T. Tapak, Learned Counsel, for the respond number 8 in WPC 94. While subscribing to the submissions made by the learned additional senior government advocate, submits that out of 58 petitioners in both the writ petitions, only 9 petitioners are genuine and 9 petitioners are only only 9 petitioners are the resident of the Singha village under Singha circle, and rest are non-resident and from a different district of the state, district of Arunachal Pradesh, who doesn't have any locus to file this present petitions. He further submits that will not record that refugee and all this stuff. Therefore, apart from the petitioners, the efforts from the writ petition being unmerited, the same are liable to be dismissed on the ground of locus to file this writ petition. Next. Due consideration have been extended to the, has been extended to the submissions of the, and advised by the learned counsel for the parties. And also peruse the reports, peruse the materials placed by the respective placed by the party, materials available on record. The law regulating to the law regulates the forest are the Assam regulation, Assam Forest Regulation, 1891. Which has been adopted by the state of Arunachal Pradesh. It regulates the constitution of any land as reserve forest. List of section. What is this section? Section 5, section 4 and 5 provides for constitution of the reserve forest. And the manner of such constitution by the government is provided. Manner and procedure for such constitution is provided, are provided. Section 11 provides which is reproduced here in below, Assam Forest Regulation 18, Section 11, page 6, volume 1, Assam. Then section 9, Next page. Section 9 provides for the constitution of village forest. Which provides that the state government by notification in the official gazette constitute any land at the disposal of the government a village forest for the benefit of any village community or group of village communities, and may vary or cancel any such notification. It further provides that every such notification shall specify the limits of such village forest. Section 31 provides that all claims to any rights other than the rights of the village community or group of village communities for the benefit of which such village forest is constituted shall be inquired into, recorded, and provided for in the manner prescribed by Chapter 2 of the regulation. Yes, Section 31 is there. The state of, next para, state of Arunachal Pradesh enacted the Arunachal Pradesh Ansal and Village Reserve Forest within bracket Constitution and Maintenance Act 1975. To provide for constitution and maintenance of Ansal Reserve Forest in Arunachal Pradesh. List of Section 3 provides that the state government by notification in the official gazette, constitute any land other than reserve forest, bracket close, at the disposal of the government as an Ansal forest reserve in the manner provided in Chapter 2 of the Assam Forest Regulation 1891. Which is notice that the said Act has been amended in 1984, whereby the word Ansal has been deleted and substituted by village, the word village, huh? Mr. Next paragraph. By the said amendment, Section 5 within bracket, Section 5 capital A has been inserted, which provides as follows. Huh? Section 5A, huh? That is volume 4, page 113, 84. You quote that, huh? Next paragraph. On careful reading of the above provisions, for the purpose of constitution of village reserve forest, the manner and procedure has been clearly laid down. It transferred that the government has the power to consider the village reserve forest for the benefit of the villagers, which is at the disposal of the government, over the land which is at the disposal of the government. It also provides that the revenue earned from each village reserve forest shall be shared by the state government and the concerned village panchayat in the manner provided therein. This one. The constitution of such village reserve forest is basically for the benefit and of the villagers of the area. This stuff. Next one. On consideration of the materials, comma, it reveals that the Gram Panchayat, the Gram Seva was conducted under the chairmanship of Ansal Samiti. Ansal Samiti chairperson. This stuff. Though the learned counsel for the petitioner has vehemently submitted that the resolution being the Gram Seva being shared by the Gram Seva being conducted under the chairmanship of Ansal Samiti and not chairperson of the chairperson of Gram Panchayat, comma. The resolution adopted in such a Gram Sabha is void. List of the on consider that effort, he has alleged forgery alleged that he has alleged the forgery of these signatures, alleged forgery regarding signatures of the persons said to have been attended the Gram Sabha. List of the petitioner. And some of the petitioners have filed a complaint, FIR and a complaint before the appropriate authority and the court which is said to be pending for trial. List of having considered that such allegations of forgery are pending before the court below, comma, this court is not has refused to delve into the veracity or otherwise of such resolution. However, on the bare perusal of the resolutions, same has been in the considered view of this court, same has been adopted after the Gram Sabha meeting. The resolutions once adopted by holding a Gram Sabha may not have any relevance. The non-adherence to the provision of the Panchayat Raj Act 1997 would not have any relevance for the purpose of considering the resolution. It may be an aberration which this court is of the view that would not have any effect. Will not have any effect on such resolution. The next paragraph. Pursuant to such resolution, an agreement was entered into, represented by the Ansal Committee member, Gram Panchayat member, Gaburas, public and other stakeholders, and clearly and had unanimously decided to donate the degraded community land voluntarily for constitution of the Idu Keba BFR. Which is interest and benefit of the villagers of the area of single circle of Upper Subansiri district. Basing on such resolution and agreement, the Deputy Commissioner has issued the issued the certificate of mutation and non-encumbrance certificate on 30/10/2015. Thereafter, the authority has issued the preliminary notification on 05/1/10/2018. Mr. For constitution of Idu Keba. In accordance with the provisions of the relevant, accordance with the provisions of the Assam Forest Regulation 1891 and the Arunachal Pradesh Ansal Forest Reserve within brackets Constitution and Maintenance bracket clause Act 1975 for constitution of proposing to constitute the Idu Keba BFR for an area on an area of measuring 47620 hectares at Singa Circle, Upper Singh district. It is noticed that in the preliminary notification, it is noticed that in the preliminary notifications, effort from it is noticed that the preliminary notification has been issued as per the power conferred by the Act and rules, and it also provides to appoint the secretary within bracket GA, Government of Arunachal Pradesh, to hear the appeals under section 15 of the regulation, which is in consonance with the provisions of the relevant above Act of the regulation. The order dated 11/03/2020 is also in accordance with in the considered view of this court is in accordance with the provisions of the Act and Rules, Act oblique Regulation, wherein it clearly has invited the HGBs, public oblique landowners oblique stakeholders falling under the EDUCABA BRF to attend the meeting and to file claims and objection for construction of BRF. Mr. Next, having considered the materials as well as the provisions of the that act so and so, Arunachal Pradesh so and so, and Assam Forest Regulation so and so. Come on. I am of the considered view that the authorities have acted in accordance with the provisions of the Act and regulations for constitution of to constitute a EDUCABA BRF list of. This court finds no infirmity or any illegalities, the infirmity or infirmity in the said proceedings, in the entire proceedings. List of the entire proceedings adopted by the respondent authorities. List of the proceedings by respondent authorities rather is of the view that the respondent authorities have acted in accordance with the provisions as required to be followed under the so and so act and regulation. Mr. In view of the discussions and the conclusion made herein above, comma, I find no infirmity. I find no infirmity or any illegalities in the process of constitution of EDUCABA BFR at Singa Circle, Upper Siang District. List of. Accordingly, I find no merit in these writ petitions. List of writ petitions consequently are dismissed. It is made clear that the dismissal of the writ petition, this writ petition shall not in any way shall not in any way constitute to be a decision, shall not influence any decision to the allegation of perjury or veracity of allegation of perjury before the appropriate forum. All right. Thank you. We'll add something to proceed further to complete the process from the date of that hearing for object claims and objection. All right. Or we may directly to fresh issuance of claims and objection. Last order by the ADC, including all the stakeholders, including the petitioners. That I'll provide, huh? So that they can complete. Because you have a right to be heard under the act. If you are really villagers of that village. Yes, sir. What is the instruction? I'll see all the pages, don't worry. Yes. 65. Since where it is? Para 3. Line. Does. Yes. No, it's okay. It's okay. You go further. Therefore, the claim of the appellant that plot of land in question is his ancestral property and his further claim that the said plot of land is under the occupation since is false. The said plot of land in question has been earmarked for industries department. The department concerned has already constructed RCC quarter for ADI in Kyo. Sir, go to civil court. Yes, it is also fact that the appellant has also been allotted few plots of land within Yingkyong Township by the government against land allotment application preferred by him. The fact that the several landowners of Gete and Sumong are residing within Yingkyong only after obtaining land allotment order from the government. Testifies they are acknowledging the fact that the land falling within Yingkyong belongs to the government. You have been allotted the land also. If you are allotted, then how can you say rely that it's under still process? 30. 30. This is for what? This is for what?
This is so that they don't have that much of land except for otherwise for 2,760. Because 5 rupees per square meter is the premium and 13,800 is the approximately they are paying. And secondly, in this case, kindly see nowhere the seal of the state bank is there. Treasury channel, of course, not treasury channel, there I will see.
Sir, will not go into all this thing. We go by that the land has been allotted to the department. You are claiming we're not dividing, we're not hosting out. You have a right to file a suit if you claim that. No, in that case, you have to withdraw. In that case, you have to withdraw. Or we'll have decided on merit. This case was on withdrawal only this. In fact, I don't believe in passing such order. Either decide on merit, or if you are withdrawing, nobody is stopping you to avail the remedy. And they are not so powerless that you cannot file an injunction, is not it? Because this order 60, I mean, which you have referred is an executive order only. It's not a judicial order. Under the act only. So always that can be looked into by the appropriate forum, not necessarily before the court. In that case, you will have to withdraw the writ petition. Yes, we may, taking the lenient view. We cannot stop them. For 1 month, we'll give them to file at least if they want. If not, we'll see. No, 1 month. But you have, your deputy commissioner has also passed an order that is still yet to, it is under process of acquisition. How you can say that? Anyway, he's not pressing, he's withdrawing. So discretion is with me now, with the court now, not with you. And Mr. Titi Tara, learned counsel for the petitioner. and also had MS P. Sangita, Learned State Council, representing the state respondents. Next para. By filing this writ petition, the petitioner has put to challenge the proceedings under Arunachal Pradesh public premises within bracket, the eviction of unauthorized occupant, bracket close, Act 2003. List of the petitioner claims that an approximate area measuring 600 square meters, which is under his possession since 1990, is not a government land. Please stop. The government has not occupied, no, please stop. The government has not acquired the land for establishment of Yingkion Township, which is evident from the order passed by the competent authority that the proceedings for acquisition or establishment of Yingkion Township is still under process. Please stop. The claim of the petitioner is that since the land under his occupation is a private land, and without any acquisition, same cannot be. The petitioner cannot be deprived of his right to have his private land, which would violate the Article 300A of the Constitution of India. Mr. Next para. TT Learned Counsel appearing for the Learned Counsel for the petitioner. After arguing the matter at some length, fairly submits that he may be allowed to withdraw the present petition with a liberty to approach the competent civil court within a period of 1 month from today. Within a period of 1 month. Please stop. Please stop. Having considered the matter, having considered that the issue involved is purely a disputed question of facts, and considering the submissions of the fair submission of the Learned Counsel for the petitioner, the prayer of withdrawal is allowed. The prayer of withdrawal is accepted. Accordingly, the writ petition stands dismissed on withdrawal. with the liberty to approach the competent civil court for different civil court list of next paragraph on the vehement prayer of the learned counsel for the petitioner, comma, it is provided that till the provided that the petitioner shall approach the civil court, approach the competent civil court within a period of 1 month from today. If so advised, please stop. On such, till such approach, was there any interim prayer here? Interim order here? Any interim order? Interim order passed by this court on 28/09/2021. Is extended, Mr. It is provided that in the event, comma, the petitioner fails to institute, fails to approach and fails to institute and by filing appropriate, by fails to institute appropriate proceedings before the competent civil court within a period of 1 month, comma, the interim order so extended, the interim order as extended above shall stand automatically vacated. List of next one. Needless to observe that on initiation of such appropriate application, comma, the Court of Competent Civil Court, Competent Civil Court, the Competent Civil Court shall decide, shall consider and decide the such application that may be filed by the petitioner on its own merit. On its own merit. The writ petition stands disposed of.